Listing the matter. Okay.
They say to matter number 3. They say to matter number 3.
Please wait. Any other matter?
May I please your lordship, my lord, custody for more than 7 years.
Please give.
Obliged, ma'am.
Right, to not see it quick chapter.
Please wait.
GLS WPC 14454 by 22.
What do you want?
Rajit Asilan. GLS 2014.
Give it.
Weekly list item number 1.
Item 38. We are appealing for opening number 4. Counter is read in course of the day 5. So let it come next week. Item 38. Course of the day counter.
Which for the petition?
Petitioner for Mr. Swine.
Intimate him. Otherwise, in his presence, we can adjourn.
Yes.
Otherwise, he might have filed memo to wish this matter more. Okay.
This comes second time.
It's all
Initially notice was issued, and then in
it is better to adjourn the matter in his presence. Just that much.
Yes.
Yes.
Item 32 will be taken up. Item 32 will be taken up.
Okay. Yes.
And item 1 become infructuous because bank in between approach CJ, madam.
Hearing for the bank submits that the matter has become infructuous. In view of such submission, the petition is disposed of as infructuous. Yes.
Item number 2.
Maybe item number 2 on behalf of Mr. H.S. Satpathy, my lord. He is some difficulties, my lord, and it will be this matter taken up next week, my lord.
Appearing for the other side. Mr. Yes, that notice.
Notice of which year?
That is annexure 9. He has not mentioned which year of it and what is the status because this WPC is of the year 2023. सरकारी जगह रे कौन बोले घर
And enforcement is of 1978.
हाँ नहीं सी गोटे कौन annexure 9 तार डेट भी किसी
किसी ने cause of person केवे रखो
किसी देगा so why you want adjournment of
He is some personal difficulties, my lord. He is some personal difficulties, my lord. Can this matter?
adverse position पे से तार होते हैं civil suit करनी
representation ଦେଇଥିଲା annexure
1995.
19 to 1990
agar भी non appears
so there has been for adjourning the matter since the case has already suffered adjournment and this is a matter petition of the year it is not inclined to adjourn the matter. The petitioner has brief direction inter alia so on so forth. It appears from the pleadings also the annexure 9 that it was a government land on which construction has been and notice has been issued for eviction by the Sambalpur Municipal Corporation. No date has been mentioned when such notice has been received by the petition. The representation has been annexed to the petition which is of the year 1994. In view of the state of affairs, after going through the pleadings, we are not inclined to entertain this petition, which is accordingly dismissed. Yes,
Item number 3,
Right. If the petitioner is arranging funds to clear up the loan and all.
there is a 13-4 notice you have.
Position
Of course, the
notice is available.
alternative remedy is available. He has to apply. Please give the name so that it can be.
2 weeks after.
Alternative remedy available, disposed of. Yes,
item 4,
please give the name in the. Yes.
Item 4 may proceed.
Yeah.
On previous date, my lord, it was directed to take instruction whether similarly placed persons have been appointed on trade scheme, my lord. RNR policy 2006. My lord, you have sought for the instruction not received till date. My lord. Some more time may be granted.
You are for whom?
I'm petitioner.
You are for the petition.
My
So who is to take instruction?
Learned counsel for the petition submitted that similar, that is the order dated 12/9/2024. The last page of that order, page 3. Learned counsel for the petition submitted that similar persons have got the relief and drew the attention of this court to paragraph number 19 of the writ petition. So also to annexure 9 series, but fairly submitted that the projects are different, and so far as the case in hand is concerned, it relates to Deo medium irrigation project at Karanjia, and seeks some time to obtain instruction as to whether any displaced family under Deo medium irrigation project currently has got the relief as has been claimed by the petitioner. So what you want, some more time?
more time, my lord.
Yeah. Land counsel for the petitioner that as per the order dated 12/9/2024, he may be given some further time to obtain instruction. Put of this matter, the 2 weeks for conference.
Not supposed.
item number 5,
On behalf of Mr. S.S. Kashyap, Mr. Satyashindu Kashyap, learned CGC man.
Yes.
On behalf of Mr. Satyashindu
Email
Kashyap,
appendix.
learned
Ah,
CGC, he's appearing for my learned senior is appearing for the caveator. We'll serve a copy on.
I don't need the copy on this matter is filed 2-3 months back. And till date, they are getting it listed. On the other hand, the pensionary benefits have been held up, and that content filed before the law tribunal, that
what
is
the problem
proceed.
today?
So we have not served the copy, my lord.
Let
That
us
is,
to argue the matter.
my lord.
So why are you?
My lord, then my lord, it may be pass over, my
This
lord.
is available here, my lord.
May be pass.
My lord's board.
So, you want it today or any other day?
My lord,
Is
any other
Mr. Kashyap
Mr.
available
Kashyap,
today?
he's on his legs, my lord. Kindly it may be
Pass
taken
over.
up tomorrow, my lord.
All right, can
Tomorrow, my
taken up tomorrow. All right,
My name may be reflected because my date
please
is
give the
there.
name and give that copy to him also.
My lord, my obliged.
So on, so land council caveator is present. Mention is made on behalf of Mr. Satyashindu Kashyap. He is the counsel for the
My
Union of India.
my
Central Government Council.
Central Government Council.
Central Government Council to adjourn the matter till tomorrow.
Fine.
Put up this matter on 29th of October 2022. Hello?
Obliged.
Copy of the writ petition be supplied to the London Council. Hello? And his name be reflected in the petition. Not currently.
item number 6,
My lord, the entire land of the petitioner's family has been acquired for by the MCL, my lord.
And by that time, the petitioner's father was overaged and the petitioners were underaged by that time.
You have submitted a representation in 2018.
Yes, Madam. 2018, I received compensation
No, what is this representation? Why you have annexed it?
because that has to be considered by the authorities.
No,
my lord.
has it been considered or not considered?
Not considered, my lord.
But why are you waiting for 6 years?
Because that has to be placed before the committee, my lord. Not yet placed before the committee,
So you just filed a representation in 2018
my lord.
and then sit over the matter. All on a sudden, you rose from the deep slumber and filed a writ petition in 2024.
Because
So
my
how
lord,
do you explain it?
because we cannot, we are helpless, my lord. Because the
It's all right, but helpless does not mean that
unless that is
we do
considered by
one thing. We are giving you an opportunity to file a phrase representation indicating all the details, and if you file it within 15 days, then that will be considered within a time limit, and the result will be communicated to you.
Right.
All right. Well done. The writ petition has been filed by the petitioner, so and so, with a prayer for consideration of their case for employment rehabilitation like the similarly situated person. As it appears, the representation was filed on 24/7/2018, which has been annexed as Annexure 3 to the General Manager Eve
Valley area.
area, opposite party.
No, he is not in.
Not an opposite
No.
party, right?
So Eve Valley general manager,
my lord. Because that is to be considered by the, he has to send it to the collector.
For providing employment against land acquired in village. So and so lekha hai Annexure 3 re, hala? The Land and Council for the petitioner submitted that the petitioners have got no response from the General Manager Eve Valley, so and so. However, the Land and Council for the petitioners is unable to explain as to why there is inordinate delay in the court if the said representation was not acted upon. Be that as it may, the Land Council for the petitioner seeks permission of this court to file a fresh representation indicating all the details before the concerned authority within a period of 2 weeks. And further phrase that the direction may be issued to the concerned authority to consider the representation in accordance with law within a stipulated period. Land Council for the state has no objection to such prayer. After hearing the Land Council for both the parties, this petition is disposed of. Given that in the event the petitioners file representation before the concerned authorities in connection with the employment rehabilitation, as they belong to the project affected family for the project Coal India, the same shall be considered by the concerned authority within a period of 3 months, the usual direction from the date of receipt of the representation and before the concerned authority. Writ petition is disposed of. Yes.
Item number 7.
Please, on behalf of Mr. Pradhan, I'm appealing for
Yes.
petitioner. Oklanama can be accepted with consent. This is a matter of the Joan lease, and second round litigation is Annexure 8 is under challenge. You will also will find that entitlement, everything is cured. Only thing, the Annexure 8 region is rejected by the learned ATM.
You come to the reason that is mentioned in page 46.
Yes, my lord. With regard to
In view of the above, I'm satisfied that read it out.
yes, my lord. 46 and that 3 regions are outside.
Yes, please place it.
Yes. The revision report had initiated a suo revision on the basis of material irrelevance and order passed on order dated 37 to 1998, is within 14 years of sanction of breach. though the appellant purchased the land subsequent and are over possession of the same, the claim of the prisoner over the land cannot be accepted as the land was leasehold and lease was granted to the lessee for the purpose of agriculture, which has been rightly cancelled by the regional authority. Many clause 3 also in many instances the Honorable High Court have observed that a right of law exists only when it is lawful origin, and it had ordered that initial stage is bad in law, then further proceeding also becomes necessarily satisfied.
Now you come to the same page where you started that reading. Come to that D,
Yes, my lord.
classification of the land.
Yes, that is a with
Please,
regard
please
to
read it. Please read it.
classification of land in the Sapik Arwar is Kochila Bono,
Mm.
which means that it was forest land, but the Tahsildar on 23rd 789 has mentioned in the order sheet that classification has been changed from Kochila Bono to Puratan Patida, while the legislative proceeding number is there, and Arwar has been accordingly corrected as per the Forest Reservation Act 1980. The Tahsildar is not competent to sanction forest land without obtaining NOC from the government MD.
So what is the power of the Tahsildar to change the classification of the land?
To
If
that
he has no power, then it goes to the root of the matter.
Yes, Lord.
And if it goes to the root of the matter, then that 14 years is no bar. So that is how the it was. So how do you say that in what way the order is wrong?
My humble submission is that so far the lease of entitlement right is already decided by all High Court. Two decisions is there. Number second, your lordship posed me with regard to Kochilaban. As I read from the OGLS Act itself, Kochilaban is not come under the forest product land because there is no growth. It matter has been inquired. The present existence of the land was vacant land, Patito land. That's why there is a formal steps has been taken by the Tahsildar before issuing a lease by inquiring the matter. The definition says there is no question of Kochilabon or any Salabon. The definition must be produced by the authority.
Question is who has granted you the lease?
Tahsildar.
You means your the person from whom you purchased the land.
No, I am the lessee. I am the original lessee. Some of the land I am sold. I am the original lessee.
Okay.
Jawan.
All right. So you have got the lease from who? Which authority?
From the government on the basis of Jawan scheme of the government
who
grant.
Who is that authority who granted you lease?
That is Tahsildar.
Tahsildar, right? Yes. So question is that when the land has been recorded as Kochila Bono, and it is a forest land.
According to
just a minute, can that land be granted lease to you without obtaining NOC from the government of India?
If it is a forest land as per the definition of the OGLS Act, definitely your lordship correct in the observation that it should not be granted.
Yes.
So far the section 3 is concerned, Kochilabanj is not there mentioned in the land definition. Is the forest land.
No, it is under the Forest Act.
Number 2, once a grant has a government grant act is separate thing, OGSL is separate thing. Government grant act has been sanctioned.
No, who changed it from that mutation proceeding?
Conversion
kiye kala, whether he has authority to do it. Or manu kar dekin dei da uti lease. Thila Kochila Bono, ଆପଣ କେମିତି ତାକୁ mutation ରେ ତାକୁ change କରିଦେଇକି ଜଣକୁ lease ରେ ଦେଇଦେଲେ?
Page 22 ରେ observation ଦେଇଛନ୍ତି, and your lordship have glanced through the circular itself. 2 points I am raised in the petition. Whether the OGLS Act is applicable to this case, if it is a Government Grant Act 1958. So number 2 is Kochila Bono, they have to satisfy the authority to give the notification that such and such property has been comes under the Forest Act. And definition there.
Where is that mutation proceeding?
Mutation page 22.
Page 22.
Yes, please. Page 22.
What he has considered changing the classification? Which order he has passed?
Page 22.
26,390.
Yes.
So he himself has taken this.
So,
I permitted to read it.
Yes, read it.
The case record is put up today. All the observations have been complied. SR has been back after service. No objection has been received from any quarter. During the statutory period of objection, the service of Istahar, being on the report of the arrest on the Chandaka, reveals that land applied for the free from encroachment and there is no first growth of the timber value. The report of the RI Patrapada reveals that the applicant has got no agriculture and land except the 40 decimal of homestead land in his village, and the annual income of the applicant is rupees 80 from so and so so and so. The applicant has in his affidavit stated that he has no other source of income and it has affidavit by number 80 is attached to the case. He has also declared that affidavit petition and not a family of the other within the time of commitments has got as such the applicant is considered to be a landless ex-serviceman and is entitled to land concession by rule 11 of schedule 2 of the OJS Act 1980. As per geo number so and so, ex-serviceman is entitled to settlement of the land of the and class 1 land or its equivalent in other classes of land, so that the land settled with him and the land owned by his family. According to that, the land to the extent of 3 acres land, class 3 land is settled with so and so, so and so, and district of the during period of the equivalent, and the acre 1 of the class 1 land computed with this one so and so.
What is your submission? Let us say that there is a circular is there that ex-serviceman is entitled for settlement of one standard acre.
Yes, only with regard to forest land.
It's all right, but if that particular land is subjected to some forest laws, whether that is required to be followed or not followed, any land can be given.
No, I do agree with lots of observation that number one, the Kochilabana definition has to come into in the input order. Whether Kochilabana, if it is not in growth, everything in the jungle, in the every land is has to be treated as.
ସେ ବିଷୟରେ କିଛି discussion ହିଁ ନାହିଁ.
Say that is the illegality of the
RI report. There is nothing, and RI is the person.
RI report.
Is it enough?
ATM also not discuss about anything or contention. That whether government grant act is applicable under the
government ଆପଣ ପଢିଲେ ସେଠି କୋଟ କରିଛନ୍ତି ସେଟା ଜିଓ ରେ ଖାଲି କୁହାଯାଇଛି ex serviceman ଗୋଟେ standard ଏକର ପାଇବାର ସେଇ ଯୋଉ standard ଏକରଟା ଦେବେ ଯୋଉ ଜମିଟାକୁ ଦେବେ ତାର ଯୋଉ ନୀତି ରହିବ ନିୟମ ରହିବ ତାକୁ ଫଲୋ କରିବେ ନା ଯାହା ନାହିଁ ତାହା ଦେଇଦେବେ
ନା ତେଣୁ ଆମେ ଯେତେ ପଏଣ୍ଟ ଉଠେଇଲୁ ଏଟିଏମ୍ ପାଖରେ whether Kochilabana is defined under the forest act notification of government of India ଯେ this particular land or kism of land in the particular of the that must be conservation forest pass କରିବା କଥା notification ସେ notification is silent ତାଙ୍କୁ ମାଗିଲେ କିଛି ଆସିଲାନି thereafter ମୋ କହିବା examine କଣ counter ଗୋଟେ affidavit ସେ ମାଗୁନି କିଛି ମାଗୁନି ମୋ କହିବା my humble submission that there must be clarity in the implementing order also. We have taken steps that let us come forward with the document or any circular of the government that such and such property or such and such property has notified as a government land, forest land. It's a government land. But with regard to Kochilabana definition, he has not come out to this. Rather, Tahsil has come into existence. They come into finding that she deputed RI and obtained a report from the RI.
No, RI report is that only because growth is not there, it is not a land. How can it be?
There is no existence.
Clearance from the forest ought to have been taken.
There must be a physical verification with regard to from the date of application itself. What the nature of the land must be inquired into.
ଗୋଟେ ମନେ କରନ୍ତୁ ଗୋଟେ particular area ମାନେ declare ହେଲା it's forest area. Let us say ସେଇ forest area ଗୋଟେ part ରେ
କିଛି ନାହିଁ କିନ୍ତୁ ସେ forest land ଧରାଯିବ କିନ୍ତୁ ସେଇ ଖାତା ମୋର submission
କଣ ଲେଖିଲା ସେ ଆପଣଙ୍କ RI କଣ ଲେଖିଲା ଯେ ଏଠି କିଛି growth ହଉନି ମାନେ forest ଭିତରୁ ଯେକୌଣସି land ଆପଣଙ୍କୁ ଦେଇଦବ ଗୋଟେ ଏକର ନା କଣ
ନାଇଁ
କଥା ତ ସେଇଆ ହଉଛି ଆଉ କଣ
ନାଇଁ ATM illegally
ବଣ ହିସାବରେ ରେକର୍ଡ ହେଇଛି ସିଏ କହିଲା ଯେ ଏଇ ପ୍ୟାଚ୍ ରେ କିଛି ନାହିଁ ବଣ ନାହିଁ ବଣ ଭିତରେ ବହୁତ ଜାଗାରେ ମଧ୍ୟ ଖାଲି ମାନେ କଣ ସେଇ ପିସ୍ ଟାକୁ ଦେଇଦବ ତାକୁ ଯୋଉ ଲ deviate
No, no,
even without the permission of the authority.
Your lordship directed the ADM to reconsider the matter
Yes,
afresh.
considered it as past a
Yes,
reason.
already passed.
So
They
what
only
is
the repetition of fact. ଇଏ ତାକୁ ବିକିଲା ସେ ତାକୁ ବିକିଲା ସେ ତାକୁ ବିକିଲା ଏମିତି
No.
ଆଉ with regard to କୋଚିଳା ବଣ ସେ ଫାଇଣ୍ଡିଂ କିଛି ଆସିଲାନି କୋଚିଳା ବନ 3:1 ରେ ଡେଫିନେସନ କିଛି ନାହିଁ ଫରେଷ୍ଟ ଲ୍ୟାଣ୍ଡ ବି ମୁଁ ଦେଖୁଛି କୋଚିଳା ବନ କିଛି ଫରେଷ୍ଟ ବୋଲି କିଛି ଆସୁନି ଫରେଷ୍ଟ ଲ୍ୟାଣ୍ଡ ଟା ଆପଣଙ୍କ ୟୋର ଲର୍ଡସିପ ଅବଜର୍ଭେସନ 100% କର if the land is defined by the state government is a forest land I have no case the OGLS act definition କୋଚିଳା ବନ କିଛି ନାହିଁ କି ଫରେଷ୍ଟ ଲ୍ୟାଣ୍ଡ ମୁଁ ମଧ୍ୟ ପାଉନି କିଛି କୋଚିଳା ବନ ଗୋଟେ ଫରେଷ୍ଟ ଲ୍ୟାଣ୍ଡ he has to give in the document with regard to the notification of the department forest department no kimba apankar government of revenue department he has to show the ADM has to reflect that
is your paragraph number page number
40
you come to page number 40
yes sir.
page 40 re upon paragraph 9 को आसन
Okay. That it is respectfully submitted that the opposite party in the implemented order this court has stated that opposite party land is Kisam Kochilabad, a forest area. But the land Tahsildar number observed that classification of the land changed from Kochilabad to Puratana Patita and by mutation proceeding number 8 and ROR has been accordingly corrected as per the Forest Conservation Act. The concerned sub-collector and Tahsildar being the competent authority to sanction the forest land by obtaining NOC from the government of India. The present case and procedure has not been made by the sub-collector and Tahsildar for change of Kisam.
This is their objection.
Yes, sir.
Yes, now if
On the next.
yes
That as per the government of Orissa Revenue Excise Department and so notification number communicated to the Secretary Board of Revenue Orissa Cuttack regarding classification on allotment of land to exfoliated servicemen, wherein it is categorically stated that under Government Grant Act, sanction of government land is to be done by the government. There would be considerable delay if all such cases are referred to government for sanction. In consideration to the difficulties, it has been further decided that Tahsildar will be competent to settle land with aforesaid category of Jawan under the provision of Government Grant Act, conferring the status royal as defined under OLR Act 1960.
So according to you, the Kochila Bana Kisam of land
Yes.
is habitable.
Yes.
Is it not?
Yes.
So what was the need of conversion? What was the need for conversion in 89?
That is
If it was a habitable land,
Yes.
what was the need for conversion?
that was a formal reason that was not necessary. I think so.
How can you say that?
So, let us government council may show the Kochila Bana is a forest land. That's all. And so far government grant other absolute is not necessary because government has come to a conclusion that even if government grant act hela which is lesser government nobo. So we cannot go into that ratio. With forest land and OGLS act, the Kochila Bana definition is commander of forest land. That's all.
Does this applicant fulfill the other criteria of
Everything,
circular?
everything.
main
Only forest. ଆଉ
ତା report ଅନୁଯାୟୀ
ଆଉ ଗୋଟେ ପଏଣ୍ଟ ଅଛି ସବକଲେକ୍ଟର ଦସ୍ତଖତ ହେଇଛନ୍ତି ସିଗ୍ନେଚର ଡେଟ୍ ଟା ନାହିଁ
That is not.
that is ଯୋଉ ଲେଖିଛି paragraph number 2 ରେ
ଇଏ
ସେଟା ହଉଛି internal page ହଉଛି 13
yes ma'am
the confirmation letter of sub collector last one
ଆଜ୍ଞା
2A
ଆଜ୍ଞା
of sub collector does not bear any date ସେଟା ଗୋଟେ Peter Syed Mohammad's application for lease was considered because he was an ex-serviceman as mentioned in the application. So on same application to collector to consider them after due verification, the applicant has filed the affidavit about his ex-serviceman status, but no further verification was made by Tahsildar. The OGLS Act in Section 3 has provided that settlement of land under the Act shall be made in order of priority in favor of so-and-so landless labor.
No, does he fulfill the circular
yes madam
under annexure 6
556 yes yes
within that period?
yes yes only the forest land
He was a Jawan within that period.
Yes, the better.
26/10/62 to 64.
Oh, ये बोलेंगे yes. Technically, the date of the subcollector not mentioned, and another is a legal aspect is that is forest. If the forest it will be defined or not defined, then I have no case at all. The other matter will be settled whatever. Alternative.
So what do you say, Mr.
I'll take instruction.
I will shout for extra copy so that
This writ petition has been filed by the petitioners challenging the order dated 21/6/2024 by the Land and Additional District Magistrate.
It as a cover kurchi
Okay.
64 to 82.
Okay.
Or that is not the notification.
Identified annexure 1 both. Annexure 1 your lordship.
6 the last career certificate.
এই যেটা
Annexure 1
annexure 6 টা দেখছেন একা একদম
annexure 6.
এটা হচ্ছে আপনার
Yes,
clarification of allotment of land to ex-serviceman.
yes, my lord.
তার ফার্স্ট প্যারাগ্রাফটা পড়ুন।
I am trying to say that as per Home Department resolution number 161, Jawan who have served in the forwarded area during period of 26/10/1962 to 31/1/64 are eligible for settlement government land wasteland of 5 acres of free land. And that is date is 26/10/62 to 31/1/64. कारण ये join करते सर मेरे 58 अच्छी है आगुर अच्छी है.
No, but in para 2 of your application, it is there that he was Indian Army from period 64 to 82.
Para 2.
Page, running page 38. You got it? Page 38.
38 my lord.
Para 2. 1, 2.
Indian Army from 64 to 82 applied to the concerned authority
Yes.
for piece of land 1989. 64 to 82. And this is order.
It is 62 to 64. 64 January that too.
Yeah. This is a letter annexure 1 as I got instruction by associate. That is a letter of identity card has been since 2058 join କରିଛି last lacha 6384
କିଏ
ସେ ଲୋକଟା ଏ ଯୋଉ ଆପଣଙ୍କର
ଆପଣ applicant
ହଁ
ଆପଣଙ୍କର applicant କେବେଠୁ କେବେ join କଲେ
applicant ନାଟା ଅଛି କଣ I am director to Impleadment
କୋଉ ପାରା
annexure 1 ଟା ସେ last ଯୋଉ ଆପଣ lordship pointed out in para 2 of the page 38 in that I am giving reply. Annexure 1 your lordship complete better. Annexure 1 that is a letter from the government to the collector allotment of with regard to make a file application, a letter has been issued by the government to the collector. Allotment of land to ex-military service holder Syed Mohammed hearing certificate number so and so dated 2/2/58. That means petitioner, the operating person. I am directed to enclose a copy of the application of ex-military service holder Syed Mohammed petitioner hearing certificate number dated 2/2 GSS 2/2/58 at post Jadavpur to say that the case may be disposed of according to the given short law and assessment short law. That means he surveyed from 2/2/58 and for that period. That is not dispute at all. Whatever Lordship pointed out, that is not dispute. Only dispute is the forest land and the signature of the collector.
So according to you, he is there since 1958.
Again. So only with regard to forest land, as your Lordship pointed out, that is the only mode question.
Then
The state
that is
council to
mentioned to be 62 to 80, 64 to 84.
This annexure 6 which you are placing,
Yes, sir. That is a period.
period je tapor paragraph to gaile according to the provisions in the OGLS Act and rules eta padle.
Right. See, according to the provision of OGLS Act rules, Jawan as such do not qualify for settlement of government land. Besides the settlement of government waste land for agricultural purpose, which anyone cannot exceed 1 standard acre. So, according to OGLS Act and rules made thereunder, Jawan as such is not eligible for settlement of agriculture. Some collectors have rightly expressed doubt regarding settlement with Jawan. Since it is not possible, next page. Since it is not possible for settlement of the government land,
Government waste land
up to 5 acres within the Jawan in terms of the aforesaid resolution of the Home Department within existing provision of OGLS Act and rules thereunder, government after careful consideration have been pleased to decide that such settlements shall be made within the ambit of Government Grant Act 1895, keeping in view the nature of the concession as reward. And under Government Grant Act 1895, sanction of government land is to be done by the government. There would be considerable delay if such cases are referred to the government sanction. In consideration of this difficulty, it is further been decided that Tahsildar will be competent to settle the land with the aforesaid category of Jawan under the provision of Government Grant Act 1895, conferring the status royal as defined under Whaler Act 1960. But that way, I mean to say, previously what was happening in Jawan matter, the GA department is the authority, was the authority. Thereafter, GA department.
That means what this instruction says that it would not be under the OGLS Act.
OGLS Act. The government grant.
Government grants. Now you come to this. This was in the year 1986.
Yes,
now you come to the Tahsildar's order, which you are placing.
Annexure 2.
Annexure 2. When that order was passed?
24/6/89. 89.
No. It is
26/3/90.
26/3/90
26/3/90.
Yes.
Order asila.
Is
so how
referring to
it is OGLS Act, it can be granted?
That first 22 points I also reading that one. Since the OGLS confirming Government Grant Act रे sanction करिबेली
and एटा कोड Government Grant Act रे आपन दिया हिची एटा त आपन OGLS Act रे दियाला लेखा हिची मध्ये ता रे जदि आपनकर instruction आसिला जे सेटा OGLS Act would not be applicable, it can be given on the Government Grants Act
as an award.
So how he has granted you the lease under this OGLS Act? लिखी जंदी पूरा clearly the lessee shall pay swans in accordance with the provisions of OGLS rules.
I mean, I'm clarifying that the Government Grant Acts was authorized to the government itself, GA department. So what happened? Difficulty arise the consonance with the Government Grant Act, the under the OGLS Act. Sorry. According to the provision of OGLS Act,
ସେମାନେ କହିଲେ ଯେ ଏଟା delay ହେଉଛି ତେଣୁ ତହସିଲଦାରକୁ competent କରାଯାଉ। But under the grants act,
government
गवर्नमेंट ग्रांट्स एक्ट रे आपन को दबार थिला आपन को ओजीएलएस एक्ट रे दबाउ सेटा
say that part has already been answered by the revision bench out अछि interpretation ହେଇଥିଲା revision ହେଇଥିଲା
कोन भी yes which paragraph you are saying
Para 7.
sorry mo dita
Para 7 it appears.
it was held here that the suo motu
Yes.
proceeding which was initiated against the petitioner by the ADM that was held to be not proper. But here is not a case that ADM exercise the suo motu power.
yes
Rather, the court has also observed that the learned additional government advocate could not reconcile as to how the government orders and principles declaring settlement of 5 acres of land in favor of Javans could be made under the scheme of the Act. In the aforesaid premises, the conclusion is irresistible that the settlement of 5 acres of land in favor of the petitioner was not made in accordance with the provisions of the Act, but it was under the lease principles read with government notifications which made special provisions for special categories of persons who could not be treated on the same footing as private individuals. That is how it has to be. Nowhere it has said. It refers to the grant only.
So it appears that as per the direction of this court in that OJC, where to inquire into the irregular cases in and around Bhubaneswar Tahsil, so many cases were opened up and it was found that there has been misrepresentation, mistake of fact, procedural irregularity, fraud, all these things were detected.
Annexure 3 show motor page 25 as it revealed from the show motor.
Yes.
First paragraph. The ATM Annexure 3
Yes,
page
that was the order of this court.
Order of the ATM. First order of the ATM. First order of the first line. This revision is on my own motion. He has power under OGLS Act, the ATM. The order under Annexure 3 was challenged by the earlier read petitioner, as your lordship pointed out. That has been set aside and remitted back to the ATM to afresh. ATM inquired some of the property has been alienated by me with permission of the authority. With the permission, your lordship come to a conclusion that the Tahsildar has issued a letter to that extent. Some of the property required for my treatment, I need to sell and permission at all the persons has been with the permission, with the knowledge of the Tahsildar. Only your lordship will examine that whether the Ochila Banda is come under the definition of forest, then in that case, nothing, I have nothing to say in this case. As my lord's brother Joshi said, Even though come to a finding that Government Grant Act, but not no answer to that extent. And 2 points have been raised in the petition. Mr. Vidyadhar Pradhan has raised the question. I want to also support this. Whether OGL Act in the special provision, in the special statute, Special Government Grant Act 1895, whether OGL Act is applicable, then question of Government of Forest Land. Yeah. If the Kochilaban is forest land, even if the Government Grant Act cannot be settled. Only 2 points. Well, if they want to take instruction, whatever they may, within a short period, within 7 to 10 days, you will decide a matter also to that extent.
Writ petition has been filed by the petitioners challenging the order dated 21/6/2024 of the Additional District Magistrate Bhubaneswar, passed in revision case number 1 of 1997, wherein it has been observed as follows. Quote paragraph number page 46. In view of the above, I'm satisfied that the due to achieve 1, 2, 3, 4 है से कोट कर दें dispose of for example. The Land Council for the petitioner submitted that the Land and ADM Bhubaneswar has considered the revision case record number 1 of 1997 and found that the lease suffers from different defects inter alia, that the classification of the land at a D page number 46. Classification of the land in Sabik ROR is Kochilavano, which means it was forest land, but Tahsildar on 23/7/1989 has mentioned in the order sheet that the classification has been changed from Kochilavan to Puratan Patita, inverted comma bhitor by mutation proceeding number 3020 of 1989, and ROR has been accordingly corrected. As per the Forest Conservation Act 1980, the Tahsildar is not competent to sanction the forest land without obtaining NOC from the Government of India. It is the contention of the Land Council for the petitioner that there is nothing in the Forest Act, Forest Conservation Act, that Kochilavano would come within forest land. On this aspect, stop para. Land Council for the state wants to obtain instruction in that respect, put up this matter. The week commencing from 4th November 2024. Yes. Free copy of the order and read over to
Item number 8. Petition of land was acquired in the year 2018. Last week, you has disposed of several matters of identical matter. That is
representation annexure 9.
annexure 9. There is annexure item.
So item number 8, 10.
Madam.
How good?
That is your lordship.
8, 10, 13, 14, 15.
Madam.
All are annexure 9.
My lord, same annexure. 8, 10, 13, 14, and 15.
All right. Disposed of. Yes, next.
Item number 9.
Representation has already
Use the mic properly.
Representation is there.
It is annexure 2.
13.
13
page, Milord. Annexure
13.
2, 13, page 13.
What is this matter?
Petitioner is challenging the legality of statement of accounts instruction 13/2023 to petitioner for collection of huge amounts by way of giving loan and inaction of the opposite party invoking the provision of Surface Act 2002 and rules framed therein by making an arbitrary demand 97,408 ଟଙ୍କା 48ଟା installment ରୁ already given 46. Then
No, Hinduja Finance Limited.
Miller,
Why this writ petition would be entertained? Hinduja Finance Limited, whether it is coming within the definition of state. You have availed loan from Hinduja Finance Limited and you have some dispute.
Miller,
And you said that you have paid some amount and he has not considered. And how you have submitted a representation, it's all right, but how this writ petition would be maintainable?
Surface Act allows bank and other financial institutions to take possession of secured assets of if the outstanding.
No step has been, other step has been taken.
Yes.
It is just at this stage.
Only a statement.
It is statement has been given by a private company to you and you have submitted a representation to that private company for consideration, that is to the branch manager. So how a writ petition would be maintainable?
You reconcile with the bank.
You go to the if anything, you file a suit or oppose the bank. No.
Miller.
But since this appears to be a private dispute between the petitioner and the finance company, and the so cannot come within the definition of state, this writ petition is not maintainable. It's disposed of it. Business dispute for the private dispute, no, business dispute becomes one in which he has availed loan and not cleared. So they can paragraph for you. Yes, sir.
Item number 11. My lord, the petitioner is seeking a direction from this honorable court. May I direct the Central Administrative Tribunal Kotak Bench Kotak to dispose of the pending way number 547/2020.
What is the stage now?
The stage is that, my lord.
Please
now
use the mic
count-
properly. Please use the mic.
Now the counter and regender has already been filed, my lord. Pleading are completed.
So have you filed any application to expedite the hearing there?
Yes, my lord. That is
Where is
Annexure
it?
1, my lord.
Annexure 1.
Yes. MA 272/2024, my lord.
Date of reception. Yes.
But which is also pending, not considered by that honorable court.
It's all right. Many old cases are there. So you pursue that interim application, misapplication, which is there. Why have you come here? Because this writ petition has been filed for a direction to the Central Administrative Tribunal, Kotak Bench Kotak, to dispose of way number 547 of 2020. In the writ petition, averment has been taken. Where have you taken that pleading is complete in that?
My lord.
ଆପଣ ଏଠି ଫ୍ୟାକ୍ଚୁଆଲ ଆସ୍ପେକ୍ଟ ଗୁଡାକ ଏଠି କାଇଁ ଇଲାବୋରେଟ କରୁଥିଲେ? ଆମେ କଣ ଏଠି ମେରିଟ ରେ ଡିସାଇଡ କରିବୁ ନା କଣ? ଆପଣଙ୍କ ୱେ ପେଣ୍ଡିଂ ଅଛି ସେଠି, ଏଗୁଡା କଣ ଲେଖିବା ଦରକାର ଥିଲା?
Rather date of filing, date of completion of pleading, ଏଗୁଡାକ ନାହିଁ. How can you assess that there is really a delay?
My lord, paragraph 15.
In paragraph number 15, it is stated that way has been admitted, notice has been issued to the opposite parties, and counter and rejoinder affidavit has been filed, and therefore the pleading is completed. But the way has not been heard on merit, even if more than 4 years has already passed. The land counsel for the petitioner has brought to the notice of this court to Annexure 1, which is an application filed by the petitioner for disposal of the way within a stipulated time, and the same has been numbered as MA number 272 of 2024. It is the contention of the learned counsel for the petitioner that MA is still sub judice, and therefore the direction may be issued to the Learned Central Administrative Tribunal to consider the MA at an earliest. You'll record your name, Learned Counsel so on. So please give the name. Has no objection to such prayer, considering the submission made by the Learned Counsel so on. So if the petitioner moves the MA number so and so, the Land Central Administrative Tribunal shall consider the same in accordance with law and pass order. It is made clear that we have not expressed any opinion on the merits of the MA number 272 of 2024 or OA number 547 of 2020. Yes.
Item 12.
May I please, Your Lordship? Lord, this is the second round litigation. This is the second round litigation, my Lord.
Yes.
Your Lordship may turn to page impugned order as Annex 13 at page 103. The principal conservator of forest wildlife who has not stated it is rejected the application for non-inclusions of certain villages, my Lord. The operative person at page 105. Further, the government of Odisha in Forest, Environment and Climate Change Department in the year 2016 issued the guideline extending the financial assistance support to the NTCA guidelines to the family willing to be relocated in the Sanctuary National Park Tiger Reserve other than the core critical area of the Tiger Reserve, along with some additional benefits in coverage with the different government scheme and programs. Government of Odisha rather further in the 2011 issued another guideline enhancing the package amount and extending the scheme to the families willing to relocate from the inaccessible forest areas, including area connecting wildlife habitats. In the instant case, the applicant in their representation by the Annex 9 have mentioned that the village in question do not come under the core critical tiger habitat of Satakosia Tiger Reserve. Hence, there is no need to relocate them. However, in view of the guideline issued by the state government in the year 2016 and 2021, as mentioned above, the scheme of voluntary relocation can be extended to the people willing to be relocated from National Park, Sanctuary, Tiger Reserve, other than the core or critical tiger habitats. Sorry. As well as from the inaccessible forest areas, including area connecting wildlife habitats. Hence, the above view, the applicants does not stand any merit. Further, since the relocation is purely voluntary in nature, it would not be appropriate to issue any order at this end either to stop or to go ahead with the process. However, the villagers should be made aware through appropriate forum regarding the government provision, package and benefit likely to be accrued through voluntary relocation. Provision spirit of all the guidelines is for voluntary relocation from the forest areas and have two essential aspects. Voluntary relocation of the people on mutually agreed term and conditions and obtaining informed the consent of Grama Sabha, concern and of the persons affected to the relocation program, completions of the process of recognition and determination of the right and acquisition of the land or forest right of the scheduled tribe of such other forest dwelling persons, district authorities including the forest officials associated with the voluntary relocation process shall ensure the compliance of the provision of all relevant guidelines.
Yes, but
My Lord, the fact remains the guideline was enacted by the Government of India, that is National Tiger Project under Annexure 1, Your Lordship, at page 24.
so what is your prayer?
My prayer was that, my Lord, Government of Odisha has Forest Department under Annexure 5 has issued a guidelines
Yes.
and notification at page 56.
Hmm.
Certain villages are not coming under the core area, so also not under the habitat area or any areas. That has been described in page 57 Milord of
Hmm.
the brief
Hmm.
of the district Angul.
Hmm.
The villages, those they have acquired in the name of that is voluntary allocations without making any Grama Sabha, even though it is the mandates under section 38B of the Wildlife Act, so also the scheme of the National Tiger Project and the Government of Odisha scheme. These 43 villages
Hmm.
are not coming under the provisions of that acquisition at all. However, they have acquired the same on the name that there is a voluntary allocation
Hmm.
and made the meetings in the nearby villages.
Yes.
Order?
Yes.
At Annexure 6, I have given that 16th meetings, 18th meetings, and all are the meetings they are made for relocation of the villages.
Yes.
Where they have stated that the chair, may I read only 3 sentences from the chairman of relocation committee at page 67. Chairman relocation committee come collector Angul has instructed DOPO Satkosia to motivate the villages of their village with involvement of nature lovers and environmentalists through the meeting and discussion immediately on top priorities. And these meetings has also conveyed from time to time, where the present petitioners, they have also submitted their grievance. They are not interested at all for any relocation or acquisition of the lands, because all the houses and the lands, I mean agricultural lands, has been taken into account of these 5 to 6 villages only. And our approach before the authorities there, as these villages are not coming under the relocation policies and not under the, and also not under the scheme under Annexure 5, then this should be excluded first. And even if it is accepted for the same, then provide the benefits under the policy 2006 or the Fair Act 2013. But that is the reason we preferred the rate application earlier, that is WPC number 33724 of 2023, Annexure 12. And this on call directed to consider the representation and dispose of the same. Your Lordship, the
Which
order.
representation was directed to be considered?
Pardon?
Which representation was directed to be considered?
Annexure
Yes.
11.
Annexure 11.
Annexure 11 series.
Yes.
And they have rejected the same under Annexure 13,
Yes.
saying that is a voluntary relocations. My lord, so far voluntary relocation is concerned, that procedure has been followed under the scheme by the government of Odisha, so also the NTCA. Your lordship, turn to Annexure 1. For a moment, kindly turn to Annexure 1.
No, he has mentioned that it has been taken a voluntary relocation of people on mutually agreed terms and conditions.
Yes.
And after obtaining informed consent of Grama Sabha's concerned.
Yes.
And of the persons affected to the relocation program.
Milord.
So if that has been done, then what is the harm?
There is no Grama Sabha at all.
No.
They have stated so. They have stated so, Milord. There is no Grama Sabha at all.
There is
And
so many orders have been passed that the Grama Sabha has been held and this is voluntary. So we are in a, we cannot decide in a disputed thing in a written.
no, my lord, it is not a disputed, my lord.
Then
the villages they have acquired, it is not coming under the scheme. That is one point. Second point, my lord, the act provide to perform Grama Sabha. They have made, as stated, there is a police Sabha was conducted. And even though they have, in the meantime, they have acquired all the villages and devastated the residential buildings, so also the agriculture, and not a single pie has been paid to the beneficiaries of the said areas.
So who is to comply this later part of this order? The other two.
My lord, collector. Collector Hon'Ble is to comply because he is the district chairman.
ଯୋଉମାନଙ୍କୁ ବିସ୍ଥାପିତ କରାଗଲା
ଆଜ୍ଞା
ସେମାନଙ୍କୁ ଆପଣଙ୍କର କହୁଛନ୍ତି ଯେ ଏପର୍ଯ୍ୟନ୍ତ କୌଣସି
not a single by either government of Odisha guidelines or on the guidelines of the 2013 policy.
stated so. Let us see that particular paragraph.
Yes.
Apart from the fact that whether it has been voluntarily done or not,
Yes.
where have you stated that when the requirement is that those people are to be compensated, they have not given anything. So where you have stated?
My lord, first at page 10, your lordship mechanism. Page 10 of my brief. On 7th August 2021, the government of Odisha again revised the guidelines for relocation of single individual without rehabilitation package.
Package ଆସିଲା ପରେ କଥା
ଆଜ୍ଞା
ଏ ଯୋଉ ରିହାବିଲିଟେସନ ପ୍ୟାକେଜ ଆପଣ କୋଉଠି ଅଛି ଯେ ଆପଣ ଏପର୍ଯ୍ୟନ୍ତ ରିହାବିଲିଟେସନ ପ୍ୟାକେଜ ପାଇନାହାନ୍ତି ସେଇ ଗଭର୍ଣ୍ଣମେଣ୍ଟ କୋଉଠି ନେଇଛନ୍ତି ସେତିକି
Only they have explained in page 14x. Page 14x रे हाँ next page ये रखो no grammar of आज में nothing
X
हाँ 14 page 14x
X रे कौन लिखिଛନ୍ତି
ସେଥିରେ
thus that the president so and so submitted his explanation to the so and so.
Yes, I am giving paragraph E. For that, the opposite parties E at page 18 below.
18.
Yes.
818. 18.
The opposite parties are conscious about the area of acquisition and through scheme voluntary village relocation where the person village are available within the core or the critical tiger habitats or critical wildlife habitat. Accordingly, the area has been identified by the government, has been acquired through village relocation and compensation has been paid as per the scheme. But fact remains, so far Kotrang is concerned, some villages are benefited, but 29 villages, families, though their land and house has already been acquired, but neither they have been benefited either through scheme or through land acquisition, for which they have approached the Sonal Court, written so and so. And it state that the land which has been excluded from the government notification, if the land has been acquired for the public interest, then the procedure has provided to the right to fair compensation. Instead of following the procedures as provided, the above acts, the opposite parties acquired the village taluk are provided the compensation as per the village allocations. And without any grammar word.
Mr. Pari, we just want to know that this government that they have been relocated, whether as per your guideline, those all these schemes and that beneficial provision has been given to those displaced family or the families who have been relocated or not. That is the main thing which has to be. You say that some persons have been given.
And in paragraph H, Milord, page 19.
Yes.
They're asking for 29 families.
Yes, thereafter, my lord, paragraph H. Under the notification, so and so village Purana Koto, Tikarpada, Burkundi, Pukula, Chotkoi, Tarsing are not coming under Satokosia Judge Sanctuary. The said village not coming under phase core or critical tiger area, buffer or periphery, but without any reason, the village has been evacuated without paying compensation under the right to fair compensation transparency in the land acquisition, rehabilitation and resettlement.
So this is in addition to 29 families?
In addition to 29.
Okay. So that instruction, Mr. Padi, you take that.
Yes, but the state might have.
The state has to pay.
2 and 3 will take. We are in 1 and 4, by
this petition has been filed. With a prayer to quash the order dated 21/2024 passed by the principal CCF (wildlife) and Chief Wildlife Warden, Odisha. Wherein, considering the guidelines for voluntary relocation from the forest area, it has been held that voluntary relocation of people on mutually agreed terms and conditions and obtaining informed consent of Gram Sabha concerned and of the person affected to the relocation program is essential. So also completion of process of recognition and determination of the rights and acquisition of the land or forest right of the scheduled tribe and such other forest dwelling persons is also essential. The Mr. Mishral and counsel for the petitioner submitted that referring to ground number E and
H.
E, F and H, na?
Miller.
E, H and F stated that the Grama Sabha has not been held and the only 29 families have been benefited and they have received the compensation as per the scheme. But so far as villages like Purunakot, Tikarpada, Hukundi, and Taluka, Chota the paragraph H so and so. These are not coming under Satokosia George Sanctuary and the said village so not coming under the phase of 4 of critical tiger habitat area or a buffer or peripheral area. But without any reason, the villagers of the above villages have been evacuated without paying any compensation under the right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act 2013. Let the Land Council for the issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Mr. Padil and Deputy Solicitor General of India, along with
Mr. B.K. Padi.
Mr. Padi, and central government accepts notice for opposite party number. Mr. Padi, please tell which are the
One and 4 mile. 1 and 4.
The Land Council for the state accepts notice for the opposite party. You have received a copy for opposite party number 2, 3, 5, 6, 7, and 8. Extra copies of the petition be served on the Land Council for the respective parties. Matter to be listed in the week commencing from such and such date. Counter affidavit, if any, be filed in the meantime. Specific instruction on this paragraphs number so and so shall be obtained and in the meantime also. Out of this matter, give a date after 4 weeks. Yes.
29 villagers of village Kotrong. Your lordship detected that 29 villagers of village Kotrong.
जो paragraph है सेटा देखिए
H रे
yes next
मतलब item 7 टा जो 76 वाला cannot be मतलब 11 because 4 दिन छुट्टी है तो
7
ସାତଟା ଯୋଉ ରହିଲା instruction ପାଇଁ
ହଁ
4 ତାରିଖ ରହିଛି ପୁଣି 11 ତାରିଖ ରହିବ।
ଆଚ୍ଛା ଏଇଟା 11th କରିଦିଅନ୍ତୁ ତାଙ୍କୁ ଟିକେ କହିଦେବେ
ଆଜ୍ଞା।
ସେକ୍ସନ 11th
Item number 16.
yes item 16
17 ଟା ତୁ କହୁଥିଲୁ
In this case, the present petition is
use the mic properly.
Well, the petition is arising out of an issue with regard to applicability of order number Rule 10 petition to a land acquisition reference case. My lord. The present petitioner is the recorded tenant, daughter of the recorded tenant, and the reference application was made before the land acquisition officer under section 30 for apportionment of dispute to the, and the same was referred to the civil court behind back of the daughter. When the daughter came to know that the apportionment application is pending, reference application pending, she has filed application under Order 1 Rule 10 of CPC. The referral court rejected the application by referring a judgment of Honorable Supreme Court, ignoring our judgment of our High Court and the.
Please come to that decision.
That decision they have referred. I have
Please read it, then we will go.
In para 11, in Ram Prakash Agrawal and another versus Gopi Krishnan and others, reported as Honorable Supreme Court held that it is evident from the above that a person who has not made an application before the land acquisition collector for making a reference under section 80 or 30 of the Act cannot get himself implemented directly before the reference court. That judgment distinguishable on the question of fact. That judgment is arising out of an issue where the reference.
You have.
But I have
tried to just a minute. You have tried to distinguish it in your pleadings, but in that very decision, some other decisions have been taken note of.
Yes.
Just a minute. That Ram Prakash, that
Agrawal.
That is no. This decision is Ram Prakash Agrawal, right? 2013. So it has taken note of 3 decisions of the Honorable Supreme Court. One is Syamali Das versus Ila Chaudhary, 2007 Supreme Court 15. Have you got that decision with you?
I have got that.
And the second one is Ajam Lingana versus Eleo. That is 2002 9 SCC 426. And the last one is Prayag Upanivesh Awas versus Allahabad Vikas 2003 5 SCC 561. You are right that that was not the issue in that 2013 11 SCC 296. But what about this Azam Lingana? Have you read that decision?
I brought the recent judgment of our High Court on the point.
Have you gone through that Azam Lingana case?
No, because why I had not gotten to that. The issue in the Ramprakash Agrawal was that the reference case was dismissed for default, and an application under Order 9 Rule 13 filed by a person who was not the party to the issue. Therefore, the Honorable Supreme Court.
You see this. What has been held there?
I am also giving the judgment of the.
If you see this decision, then we'll go through it. It is not that you are remediless. Just see that.
Yes.
You can file another application there, and your matter can also be referred. So that both can be heard together.
But the Honorable Supreme Court in 95 Supreme Court observed the Order 1 Rule 10 application is applicable and allowed that application. Taking note of the 95 Supreme Court, our Honorable High Court held the Order 1 Rule 10 application.
Is now that whether you are remediless or not. If
I am
certainly we can.
I am remediless because since
Honorable Supreme Courts are there.
And how then the statutory provision can be given a good while?
That is the reply by the that has been taken note of by Section 50.
And which is the decision? Let us see that our High Court says that.
The past judgment, the Janavi Naik case.
Just a minute.
The past judgment WPC 9084 of 2024.
Yeah.
this petition is by passed on similarly. The order 1 rule 10 petition was not maintainable by the same referral court and brought to this court in the writ
What
petition.
has been held here?
Held is that order 1 rule 10 petition is maintainable.
Where is it?
My lord. Para 13, my lord.
Para?
13.
Yes.
In view of such position, considering the grievance of the petitioner and taking into consideration the aforesaid law laid down by the Honorable Apex Court in Heavily Lignite Corporation Limited case, this court is of the consider that the petitioner being the legal representative of the original purchaser who purchased the land such and such under the Khatana have a right to be considered for apportionment of awarded amount along with other claimants who are parties before the London Senior Civil Judge. In that view of the matter, the order dated passed by the London Senior Civil Judge.
So, London Council, the decision which has been taken note of by the division bench of this court, that is of 95 Supreme Court 1004. There are subsequent decisions of the Honorable Supreme Court, 3 cases where it has been held that has not been taken into account.
The judgment, my lord.
So, if on a particular point, there are 2 decisions of the Honorable Supreme Court and subsequent decisions mean 3 decisions. So which decision is to be taken into account or we are to follow it? And particularly when the Honorable Judges who have passed this order in 2024 has not taken into account the latest decision of the Honorable Supreme. 3 decisions of the Honorable Supreme. And in this case, you have not a remediless. You can also agitate that. Your case can also be referred. That is exactly held in that case.
That what happened. The another reference case with same set of facts.
All right. That is to be, and it is to be hard together. What is
there? I may be permitted to examine the answer.
Just see that paragraph we have underlined. Please read it out.
In our view, it is not open to the appellants other than the assumed ligma to have applied directly to the reference court for impleadment and to seek enhancement under section 18 of the compensation. The only person for whom some consideration can be shown is Ajma Ligma, who had at least filed an application on by before the London acquisition for seeking reference.
Right.
This is with regard to section 8 reference, where the question of not a question of apportionment.
Apportionment provision has been very specifically mentioned in 64.
No, my lord. That is on the section 30 of the LA Act. That is old act, my lord.
Which one?
This issue arising out of old act.
Old act. All right. So where it is, collector has no right to refer this matter.
The collector has right to refer.
So it is only in an exigency when the collector doesn't, then you have a right to go to the court directly.
Right.
Is it not? So why you are bifurcating?
No, I am not bifurcating.
You go to that court.
Once the reference court gone to the under section 30, the object of the reference is
now
only apportionment.
The matter is still there before the
referral court.
Referral court. So you can file an application and you can also mention that this matter has already been referred. So my case also be referred.
Well, I will examine
so one
the position I have
with
that the order 1 rule 10 petition.
No, with all respect to the order of the division bench, probably one judgment has also not been taken into account, where it is very specifically mentioned that the court cannot go beyond the reference. No, now it is coming.
Not a question of
yes, you are not before the court.
Not question going beyond the reference.
Then
what is the reference? Reference in respect of particular award has been assessed and determined in respect of a particular land, and who are entitled to get that compensation.
Exactly. That is to be decided
between the parties who have been referred.
No, my lord. Between the entitled. There is no question of parties in section 30. The person is entitled. If that is within the parties, then matter would happen. The petitioner cannot file an application order 1.
Question is that is exactly why it has been said that if that man is not there earlier and if he thinks that he is entitled to get that relief, so he has also has a right to file that application so that his case can also be
The
Referred.
object will be
referred.
same, my lord. The object will be same. Again, another
No, no.
proceeding, another reference case, another set
So
of
if a
complaints.
specific provision is made for a specific
No,
manner, you cannot avoid it.
That my solution, that specific provision is to apportionment of the compensation amount. My lord, may I read? My lord?
Yes, that is there.
There is no question of any party that when the amount of compensation has been settled under section 11, if any dispute arises to the apportionment of the same
Right.
or any part thereof, as to the persons to whom the same or any part thereof is payable. The person, the word used in that person to whom
We
is
are
payable.
disposing of giving you the liberty to approach it.
My lord, I will examine, my lord. Since this your lordship pointed out this judgment, I will examine. My lord, next week, my lord, I will examine on this.
We are adjourning, but mentioning it.
Okay.
This writ petition has been filed by the petitioner Nandini Keshari alias Singh, challenging the order dated 25/9/2024 passed by the Learned Civil Judge Senior Division Sundargarh in LA reference case number 297 of 2013, which arises out of LA case number 16 of 2010. In the interim order, the Learned Court has been pleased to take note of the ratio laid down by the Honorable Supreme Court in the case of Ram Prakash Agrawal and another versus Gopi Krishnan and another, reported in 2013 volume 11 Supreme Court cases 296, wherein it has been held that a person who has not made an application before the land acquisition collector for making a reference under section 18 or 30 of 1894 Act cannot get himself impleaded directly before the reference court. Stop. Land counsel for the petitioner urged that the division bench of this court in the case of Srimati Jannavi Naik and others versus State of Odisha and others passed in WPC number 9084 of 2024, order dated for the 16/4/2024, has been pleased to take note of decision of the Honorable Supreme Court in the case of Messrs. Neyveli Lignite Corporation Limited versus Special Tahsildar Bracketry Land Acquisition, Neyveli and others, Air 95 Supreme Court 1004, and has been pleased to, in a similar case, has been pleased to remit the matter to the Learned Senior Civil Judge Sundargarh to hear the petition filed under Order 1, Rule 10, afresh, and implead the petitioners in that writ petition as parties to the LA reference case, and to pass appropriate order by affording opportunity of hearing to them, along with other claimants, for just and proper adjudication of the case for apportionment of compensation amount amongst the claimant in accordance with law. However, after going through the division bench of this court, order dated date so and so, it appears that the subsequent decision passed by the Honorable Supreme Court in case of Azam Singana and others versus Land Acquisition Officer, reported in 2002, Volume 9, Supreme Court Cases 4 to 6, এইগুড়াକ ଯୋଉ decisions ଅଛି ଲେଖିଦେବେ, ସେତା ଧିରେ ଲେଖା ହେଇଛି ସେ ଇଏରେ, so and so have not been taken into account, including the 2013 volume 11 Supreme Court cases 296, which has been mentioned, which has been referred to by the Learned Senior Civil Judge. the Land Council for the petitioner six time till next week to examine the decisions which have been referred to in Ramprakash Agrawal and another bracketed Supra case. Put up this matter in the week commencing from 4th November 2024.
My lord, may I just interject here?
Yeah.
The principle, my lords, the earlier, as per the law of precedence, earlier judgment of the Supreme Court would prevail as per the principles of stare decisis. Earlier judgment would prevail if the later judgments do not take note of the earlier judgment or do not expressly overrule it. The earlier judgment would prevail.
These decisions have been taken note of.
95, if the 95 has been taken note of and the law has been refined, then it's a different case.
They have taken note of.
That is,
If they have taken note of, then it's different.
95 has not been taken note of.
Then the earlier
95 has not been taken note of in
examine. If you want to argue, then we'll pass the order.
No, I mean,
You have taken time to examine all those decisions.
You examine.
You examine.
If it is not there, then the
There
principle,
are
as
three Supreme
Mr.
Court.
Mukherjee is saying, has to be
In
taken.
fact, four.
We can't go beyond that, no?
Right.
That's the principle of stare decisis. We can't go by. That's settled.
Yes.
Item 17.
Settlement in justice. The Annexure 7 is pending, page 45.
Annexure 7 is pending. It needs to be disposed of. Yes.
Item 18.
Whose name is to be
My lord,
entered?
item 18, where the petitioner, my lord?
17, my lords.
Oh,
17. In fact, the difficulty is this, my lords. They have sought for protection of their possession in the meantime.
No, we're not going to.
We are not just a representation to be disposed. We are also mentioning that without expressing any usual order, that is just representation. You are appearing for whom?
For
Mr.
2,
Mukherjee?
3, 4.
Acha, it is like, to hard Mr. Mukherjee appearing, senior advocate appearing for opposite party number
2, 3, and 4.
3 and 4, and Mr. Padi and Autta na lekha hogi.
Babita Sahu.
Babita Sahu ko na lag gaya. Central Government Council for opposite party number 1. All right. Yes.
The only difficulty is this one. Then this is the fourth time. The fourth time this issue has come before this honorable court. Now, under the representation, they are seeking a rehabilitation. In an earlier petition, it is recorded in the final order that they have accepted the rehabilitation and it is over.
Their prayer is also just that they are also praying for that. So if they can pass the order, if it has already been considered,
They have referred to that WPC one for it.
That is this judgment. Your lordship is
Judgment, earlier judgment.
No, earlier 1380. 1380.
Everything is taken care of Annexure 5.
ଆପଣଙ୍କର representation ଟା କେତେ?
Annexure 7.
7.
Annexure 7, page 45.
No, only read petition you have mentioned about 14804 of 17.
Well, ये जो Annexure 5 रे, Annexure 5 previous judgment of जोटा कि file करते हैं management.
Right.
Management of Hall is filed case. And but the court so much issued notice to the land outreach because it is a long problem. And the management expressing the inability also, my lord, like it is being taken care of.
No. What Mr. Mukherjee is submitting, Mr. Mahanti,
My lord.
whether you have filed similar representation earlier and that has been
single bench decide ହେଲା. I have disclosed all these things because I was not the conducting counsel. ये जो present Annexure 5 जो judgment का is being
ମୁଁ କହିବା କଥା ଏଇ ପିଟିସନର୍ସ ମାନେ ଏଇ କେସ୍ ସଂକ୍ରାନ୍ତରେ ଯାହା ରିଲିଫ ସର୍ଟ ଫର କରୁଛନ୍ତି ଆଗରୁ କୌଣସି ରିପ୍ରେଜେଣ୍ଟେସନ ଦେଇଥିଲେ କି ଯୋଉଟା କି ଡିସ୍ପୋଜ ଅଫ
penultimate paragraph ଟା ଖାଲି ଦେଖିଦିଅନ୍ତୁ High Court ର
ଇଜ ଇଟ୍ ଦି ସେମ୍ ପିଟିସନର
penultimate paragraph ଟା
Paragraph 15.
paragraph 38 is ଲେଖା ହେଇଛି judgment paragraph 30 ସେଇଟା ସବୁ everything is taken care of.
Just
Paragraph 15.
that
Yes,
is
order
what-
number 15.
exactly.
Order number 15, penultimate paragraph is
Right.
what I'm drawing your notice. Lordship, sir.
It's just it's a public interest.
Ah,
No, the para type. This
consider
para page
And the
38.
petitioners
No,
themselves have
page
accepted.
38, 30.
I'm consider करती सब.
As the petitioner themselves have
They are
accepted the offer of
inadvertent.
rehabilitation,
They
and
are
thus
not
they cannot
properly-
turn around and claim to continue to occupy.
They are not properly advised.
And thereafter, in the last order which has been annexed,
38.
All right, it will lekhi diyantu. Mr. Mukherjee, land counsel for the opposite party number so and so, brought to the notice of this court an order. The order dated 28/7/2016, passed in WPC number 1380 of 2015, wherein the petitioners were the parties and they filed a public interest litigation, and this court has been pleased to held that in view of the prayer made in this writ petition, the writ petition cannot be termed to be in the nature of public interest litigation, as the petitioner themselves have accepted the offer of rehabilitation, and thus they cannot turn around and claim to continue the occupy the land.
my lord, this is another order where leave has been taken away from them.
These are all
Your Lordship,
page 38 judgment re.
That is what I'm.
Leave has been taken away for filing again.
No, 30 page 30 judgment है lordship में कहानी सी. Page 38 सब लिखा है जोड़ा recent judgment का.
এটা কোন এটা কোনটো
এটারে দেখো
Now the stage judgment টা.
in fact we allow the petition just one minute notice so এটা দেখি last para in such view of the matter we allow the petitioner to withdraw this writ petition with no liberty to file a fresh writ petition. It was a self question.
another land
It
counsel
is PIL नुहे এটা PIL न चले.
ना ये सब 17 में से judgment है.
এটারে
ये जो judgment है now the stage judgment है. Page 40.
পূর্ণ জানি কি এটা এই যে রিটটা ফাইল করছেন গোটা পূর্ণ জানি আপনি কি পূর্ণ
one of the petitioners
हवा का था ये सब करे दोगा.
just a minute পূর্ণ জানি কাই ଅଛି কি সে is he a petitioner here?
I see.
Is not there.
Angi ଅଛି 8.
No.
Purnajani is not a petition.
Purnajani is not. All right. So and so filed the order passed in case of one Purnajani versus Union of India, WPC PIL number so and so, wherein it has been held that it has been the petitioner was of the said writ petition was allowed to withdraw the writ petition with no liberty to file a fresh writ petition for the same cause of action. Representation.
And the last judgment of this honorable court, which they have annexed, if your lordship takes page 38, para 15.
All right, you are for the opposite party number so and so, no?
2, 3, and 4.
2, 3, and 4.
Acha, if the representation the IG,
OP number 2 में.
If OP number 2 feels the necessity of hearing the opposite parties,
RTC OP number 5.
opposite party now feels the necessity of hearing the opposite party for disposal of the representation. The same can be opportunity can be provided. Yes, next.
Item number 18.
Item number 18.
Yes.
With the Union of India, the petitioner challenging the order of the Land Settlement Tribunal Cuttack that is under Annexure 5, page 21 of the writ petition. The crux of the issue is that a person who has taken leave on telephonic information to the department, I will leave from February to March.
No,
15th March 2010, that period was completed.
Mr. Paris, there is some delay or what? You have filed an application for condonation?
No, my lord, I'm sorry, there is no question of delay, wrongly they have filed. There is earlier practice.
Ashin. Delay nahi to?
We have filed the writ recently, but it was, the order was passed on.
Condonation of delay will there flag.
Oh, flag, they filed it, my lord, I'm sorry. It should not be filed. They filed it, but this
286
Babita sir
page only
filed
there.
it.
Fees deficient objection delay aspect କୋଉଠି ଲେଖା ହଉଛି ଯୋଉ format ରେ
His order was passed on 12/7/2022. We have challenged in 2024. That's why
It is
application file read there. Generally, there is no procedure for delay for this. Narasimha, keep it to next week. I'll verify and let me.
office ରୁ ଆମେ instruction ମାଗୁଛୁ ଦେଖନ୍ତୁ
ଆଜ୍ଞା.
IN number 14022 of 2024 is an application under section 5 of the Limitation Act for condonation of delay, and the prayer has been made to condone the delay of 286 days to file the writ petition. Since the office note doesn't reflect that whether there is any delay in filing this writ petition, let the registry place a specific note in that respect and matter be placed on 4th November 2024. क्या तारीख राशि हो Mr. Park?
Yes.
Mr. Park. And Bobita Sangana.
Item 19.
Yes.
The case where the petition or challenge is non-promotion to the post of senior clerk junior branch. And orders were passed earlier to produce the promotion file and display proceeding file and some other record. So whether my learned senior is posted with those records or not.
On 3/7/23 order.
Matters to order dated 15/12/17.
No, we are on the latest one. 3/7/23 order pauchi. The petitioner in terms of the order dated 24/23 has filed a supplementary affidavit with all the records incorporating the subsequent events that have taken place in respect of the promotion in the same post after filing of the writ petition. And the London additional government advocate sought for instruction in the matter. So what is your...
1/3/20.
Yes.
1/3/24 order where I was directed me to file an affidavit, and pursuant to that order, an additional affidavit has been filed.
The detailed developments as to the departmental proceedings, which was initiated against the petitioner and has been closed. So you have already filed.
On 6/4/24.
6/4.
That is in matter.
Acha, 6/4/24. Yes.
I have been made to pay attention to order dated 9/12/2014.
ରୁହନ୍ତୁ ମୋ ପୁରୁଣା latest ଟା comply ହେଇଛି କି ନାହିଁ ଦେଖୁ.
That has been complied. The final additional.
In your additional affidavit, what you have stated?
I have given the entire sequence with documents as to how the DP was initiated and concluded with passing of the final order.
What is that final order?
That final order is at annexed here.
Stoppage of one event without cumulative effect.
That is at page 57. May take matter to page 57 of that additional affidavit.
Additional affidavit.
6/4/24.
At page?
At page 57, madam. That is annexed to Z/3.
Z/3, no?
Madam, so can you turn to page 59? Madam, I'm placing the last paragraph. Hence, order that the delinquent be infected.
Is 59. The running page is 200 lines.
I'm so sorry.
Problem is that you are not using all these tools. Everybody is using their own files. What is the purpose of keeping these things? 222 पेज टा बाहर कर ले
All right. Yes, we got.
Hey, what's your word post? Pretty consulted.
Alexa जेल में 222 पेज
को रीड करिए पढ़ो item 20
Item number 19 of page 222 बाहर करो.
Supplementary additional data, additional affidavit. Wait. Last.
बाहर लाटी.
Again. This was
Yes, please.
My lord, I'm placing the last paragraph.
Yes, sir.
Page 222. Hence ordered that the delinquent be inflicted with the punishment of stoppage of increment, one increment, without cumulative effect, with warning to guard
Against recurrence.
Recurrence of the lapses in.
With a severe warning to guard against recurrence of such type of lapses in future. Well, this is a minor punishment, and this additional affidavit, in essence, my lord, what I humbly submit before my lords, has taken care of the entire proceeding. We have given the entire, the DP has been initiated and concluded.
Petitioner?
Petitioner is junior clerk Sushant Kumar Patnaik in Balasur Jassi.
Now he's still in service.
Yes, he is still in service. But here in this writ application, the question is, his service record was good. He was never communicated with any adverse remark. But still then he was not promoted. His juniors were promoted. They filed the writ application. In the counter affidavit,
by the opposite party number 2 and 3.
Yes, my lord.
Yes.
In the counter affidavit, they have stated
Counter affidavit
counter affidavit starts from page
47 to 51.
47 to 51.
Which paragraph page you are facing?
My lord,
Para
last page 49 starts from page 49. Reason given here for non-promotion is several allegations of nepotism, corruption, favoritism, and misconduct have been reported to the district judge not only by the local bar member but also by the More Association Advocate Club, who are tired of meeting the ever-increasing demands of Sri Patnaik. Since giving promotion to such employee will have an adverse effect on the other civil court employees, and as a warning to other employees, it was considered in the interest of the judicial administration not to promote such corrupt judicial employee. The same was also in the public interest. But the charge which was framed, there is no charge with reference to the allegation made in the counter affidavit. The charges leveled against him is something else other than this. The charges were that he got Bhutan land. That is the main charge.
What is the charge?
Charge, my lord. The charge at page 52.
Okay, that number is here. Running page 81, 57.
Xerox copy of charge. Page 81 रे मध्य अछि सेटा. 81 टा बाहर कर देले.
81, my lord. Whereas you see Sushant Kumar Patnaik during incumbency as suits clerk in the court of the Civil Judge Junior Division Balesar from such and such date, managed to file a suit being number CS 27609 of 1 in the said court styling yourself as plaintiff against the Nibedik Ancholika Bhudan Jagya Samiti Baleshwar, seeking right, title, interest and possession in respect of the Bhudan suit land situated in Mauja, Jaumuka under plot number so and so, so and so. And whereas you, fact is, you are the suits clerk in that court. Not only the present suit.
Now, what is the next?
Next, my lord. And whereas you, while filing the suit, intentionally concealed your occupation in the plaint, and Bakalat Rama so also omitted the collector Balesar to be arrayed as a party to the suit and did not bring the fact of your instituting a suit in the court to notice of the PO of the said court, and managed to obtain a collusive compromise decree behind the back of the PO. And whereas it is a settled position of law that the land of Bhudan Argya Samiti is specifically endowed for public and charitable purpose and meant for landless and less fortunate persons, you deceitfully acquired right, title and interest.
Counter affidavit ରୁ ଯୋଉଟା ପଢିଲେ
Aଜ୍ଞା
several allegation of nepotism ତା ପୂର୍ବରୁ ସେଗୁଡାକ details ସେମାନେ କହିଛନ୍ତି ହେଲା in paragraph number 6
Aଜ୍ଞା
in the counter affidavit all the details has been mentioned. It is not that the charge is different and you are they have
no, my lord, he demanded money, all these things. What is that, my lord? There is no charge.
That is an additional thing, but whatever has been stated in paragraph number 6.
Yes, my lord.
That is, see that everything is there.
My lord, whatever it may be, assuming for the sake of argument that all the charges were correct, all these allegations were correct.
Then you should have been dismissed from
no,
service.
My lord,
You are in a judiciary. And you say that whatever it may be.
My lord, all these charges have not been established. He has been exonerated from the charges. No. Only he has been given punishment on the basis of the fact that he did not take steps for early disposal of some suits.
No, that is not the only charge.
Yes, my lord. Next charge number 6 and only charge number 6 and 7 have been proved. Other charges have not been established proved.
Anyway, for that he has been given only minor punishment. It is not cumulative.
That is, my lord, after the promotion. Here the question is whether any proceeding was initiated against the petitioner by the time the promotion matter was taken up. My lord, promotion order is dated 17th May. Charge is also dated 17th May. It was not issued to the petitioner. It was issued to the petitioner after filing of the writ application on 2nd August 2011. His stand is that this charge is antedated.
This charge is dated when?
My lord?
Charge. What is the date of the charge?
Charge date is 17/5.
17/5 what? 2011.
2011.
So?
Promotion order is also dated 17/5/2011.
Yes.
So promotion matter must have been taken up earlier to 17/5. Whether the file will indicate whether any proceeding was initiated by that time, and those facts have been mentioned in the promotion file. Law is well settled that proceeding can be said to be initiated on the date charge sheet is issued. It was so held in the case of Janki Raman and Anil Kumar Rai case. But subsequently, after filing of the writ application, they took all these pleas. So from the promotion file and the promotion personal file, it
what
can
is
be
the appeal order?
My lord?
What is the appeal order? What is the appeal order?
Have you filed any appeal or not?
You have skipped appeal.
Appeal.
And you are entering.
I do not know.
Then there is a provision for appeal.
Yes, there is a provision. I do not deny that.
How can you skip? That is a statutory. That is statutory right. How can you come without exhausting that?
But after so many years of...
How can we say?
There are sitting judges of this court who are in the appellate committee and used to be 3 to 4 and they used to decide this appeal.
Then my lord, I just let it come after 1 week. I will take instruction whether he has filed appeal or not. I am not in contact with this person since a long time.
Kindly.
But the question is something different.
Again, you are making a prayer to adjourn and you again starting argument.
No, my lord.
You just take instruction. maybe that he might have preferred an appeal, and in appeal,
In
some
my
order might have
anxiety,
been
I submitted that, but since I am I would
the,
take
this
instruction.
writ petition has been filed by the petitioner Sushant Kumar Patnaik with a prayer, so and so, so and so. Since there is an appeal provision against the impugned order, the Learned Counsel for the petitioner seeks time till next week to obtain instruction as to whether the petitioner preferred any appeal or not. Put up this matter on 4th of November 2020.
Fourth will be difficult. 6th November.
Huh?
4th, I'll win.
On the 5th, 6th. Yes.
Okay.
Item number 20.
May it please. Number 1.
Yeah. I'm appearing for the OP number 2.
Item 20, on behalf of Mr. Mishra Lordship, SCR Mishra, a paid 2 weeks time to file counter lordship appearing for OP 3 to 6.
No, 2017 matter. If you don't file counter, it is up to you.
No, my lord, what has happened meantime?
Yes.
If my lord may find that the writ petition, my lord may see the prayer of the writ petition.
Yeah.
It says that counter may not, my lord will, where is the petitioner, my lord, actual petition? My lord may see at page 43. The prayer. It is therefore humbly prayed that Honorable Court may graciously please to issue rule calling upon the opposite party to show case as to why appropriate writ shall not be issued, directing IDCO OP number 1 to cancel the lease of the land and building on said number C/9 measuring 15607 square feet at Kotak Industrial Estate, granted in favor of Eastern Pan. 2. Directing IDCO OP number 1 to consider the case of the petitioner and grant the lease of land and building on said of C9 measuring 15607 square feet at Kotak Industrial Estate in favor of petitioner company within the stipulated time. My lord, this is the second round of litigation. In the first writ, when they came before this court, the Honorable High Court, my lord, may find the order at 116 of Annexure 24. In that, my lord.
What is the operative part of that?
The operating part is 119, my lord. The writ petition is full of disputed facts and prayer made in the writ application cannot be granted in a proceeding under Article 226 of Constitution of India, as factual disputes cannot be decided in the proceeding. Thereafter, my lord, they went before Honorable Supreme Court. Honorable Supreme Court order is at page 128. And my lord may find.
Yes.
The operative portion at 137.
137. Yes.
In the background, while we upheld the impugned judgment dated 18th April 2012, passed by Division Bench of High Court of Orissa at Cuttack in WCC 16790 of 2008, we are of the opinion that for respondent, IDCO should inquire into the matter to find out as to whether the land is properly used by one or other party for purpose it was open, or by opening different firms or companies in different names in same premises. They are availing loan mortgaging the same very land. For such inquiry, the respondent will issue notice to second respondent Odisha State Financial Corporation and Swasti Ferro Alloys Private Limited, Eastern Fan, and any other party who may be interested. On such inquiry, it will open for the competent authority to pass an appropriate order. Thereafter, my lord, at page 184, Odisha Industrial IDCO, my lord, page 184. This is the order in pursuance to Honorable Supreme Court directions. And my lord, at page,
please read. Please read it, sir. Sorry, if you want. Also does not have any.
My lord, just to add to that, my lord, I want to show
Swati Ferro Alloys Private Limited does not have any locus standard to claim
yes,
over set number so and so been given temporary period for specific activity which was not
and I'm
extended
showing
for
the inquiry report.
which
The inquiry report is at page 30,
that
190.
Yes, so what happened thereafter?
In 190, my lord, the operating part, the inquiry report operating part is at starts with 192, my lord. It says that I'll read out the entire thing.
No, not necessary. Ultimately, what is your
My plea is that that Swasti Ferro Alloys, my lord, they were given only 2 years time, my lord. After that, there is no extension. Even if they're doing their business in that industrial concern is without my permission.
Yes.
It was given to Prachi Enterprises. There it was again transferred to Eastern. Therefore, Eastern took loan from OSFC, and because the loan dues were heavy, so he brought in this Swasti Ferro Alloys. And Swasti Ferro Alloys were doing their business under the C9, where I had given them permission for only 2 years. Thereafter, it was never extended, nothing. And on this premises, they went before Honorable High Court, and Honorable High Court that it shows that it is purely a disputed question of fact and everything. Now, when Honorable Supreme Court asked me to make an inquiry, this is my inquiry report. And they have not challenged this inquiry report in their petition also. They filed a contempt petition, my lord, against me in Honorable Supreme Court,
Which was dropped.
which was withdrawn by them.
It was withdrawn.
It was withdrawn by them.
So you are not appearing for the petitioner.
No, I am appearing for ITCO.
Which
You are there for petitioner. Who is
No,
for
no, no. I'm for the OP 326.
Petitioner is not appearing. OSFC.
So nobody is for petitioner.
No, nobody is for petitioner.
None appears for the petitioner. The petition is of the year 2017. The Land Council for the Human Appeal Question Council. Writ petition dismissed for non-prosecution. The interim order any passed?
No, my lord. Interim order.
No
interim order passed. Yes, next please.
My lord, one thing, can I, my lord?
Yes.
My lord, can observation more submission?
No. It is not there, so yes.
Item number 21.
The petitioner has already settled the accounts and the documents have already been returned to the year, so there is no cause of actions. It is infectious.
You are for the
Petitioner.
The Land Council for the petitioner submit that the matter has become infructuous in view of the submission. The petition is disposed of. Yes.
All the document has been returned to the petitioner.
All right. Same order in the connected matter.
Yes.
Item number 22.
I will file a reply to the regional matter. Already seen.
Item 22.
Yes, sir. Your Lordship, kindly turn to page 182. This is the order of the Lordship Central Administrative Tribunal. Your Lordship heard this matter last occasion. Only my learned friend has taken the time to see whether private opposite party, private opposite parties and petitioners are in the same cadre now or not, continuing or not. Well, Lordship, that my friend has sought for the time to file a reply to legender indicating all those things. But this order was passed on 3/9/2024. The till date he has not filed that reply to legender.
I have already sent the draft copy. I have to receive. I have already sent the draft copy on 10th September. I have not received. So
for you,
could you reply to file? I will sort it.
The Land Council, Mr. Central Government Council, Mr. Rai Guru submitted that as per order dated 3/9/2024, he took time to file an affidavit in reply to the rejoinder filed by the land council for the petitioner, and also to obtain instruction regarding the present status of the respective parties. And the instruction has not been received, and therefore is unable to file the affidavit, and the matter may be taken up a week after of this in the army.
I am for the OP number 456.
11th. 13. We commencing put up this matter in the week commencing on 11th November 2024. The you are appearing for
OP number 456.
the land council for the Mr. D.K. Mahanti, land council for the opposite party number 426 is present. So also the land council for the petitioner. Mr. Vijay. Hello. 11 November 2020. Huh? Yes.
Great.
Item number 23.
Yes.
This is the matter relating to the compulsory retirement of a judge, Family Court, Nabarangpur. My humble solution is that
Just a minute.
नहीं ये भी तो नहीं कौन डॉक्यूमेंट देख के मुझे I have not given the document. Related to
Sanjeev Kumar Sahu.
हाँ
He was judge family court.
Uttar Pradesh तो register ही है तो उन्हें judge family court later on the day comes and he is now Supreme Court. I don't know. So let's say what is saying. Let me say what is
Okay. Please place your question.
Well, despite being promoted to the cadre of selection grade district judge in 2021, the petitioner who was working as judge Family Court, Nabarangpur, has been retired arbitrarily at the age of 55. Your Lordship, kindly have a glance at page 46, the impugned order. Annex 1. Notification dated 11/3/2022 from Department. In exercise of power conferred under Rule 44 of the Orissa Superior Judicial Service and Orissa Judicial Service Rules 2007, the Governor of Orissa is pleased to retire Sri Sanjay Kumar Sahu, Judge, Family Court, Nabarangpur, from the government service with immediate effect, giving him 3 months' pay and allowances, pay IRDA in lieu of 3 months' notice as prescribed in the aforesaid rules. My humble submission is that this compulsory retirement of the petitioner is a stigmatic one. It is punitive in nature and it is not a retirement simpliciter. My humble submission is that this impugned order doesn't indicate any plausible reason or principle.
No, you meant to say that the governor's order should mention all those reasons.
My humble submission is that no inquiry has been made, no adverse.
It's not a punishment, so that inquiry will be there.
I will show.
It's not a DP.
No, it is not a DP, but I will show some judgments passed by this honorable court, as well as the Supreme Court, that particularly also the notification, the circulars, those have been also violated in passing this impugned order.
Right.
My humble submission is that the legitimate expectation of the petitioner has not been given due consideration. No judicial, departmental or vigilance proceeding is pending, and that has been also certified by this honorable court.
What is there in the counter affidavit? Let us know. That
Yes, madam.
Why?
Madam, counter affidavit is at page 160.
Madam, Mr. Mishra,
169.
Yes.
169.
Which are the relevant paragraphs in the counter affidavit?
My lord, counter affidavit starts from page 169.
नहीं relevant paragraphs गुड़ा कोड़ा counter affidavit रो अन्य जिनसे छोड़ा कौन आरो विरुद्धरे कौन अच्छी क्या डेटा हम जान
Relevant paragraphs are paragraph 4, 10,
4, 8.
4, 10.
No, rule 44.
My lord, paragraph 4, paragraph 10, paragraph 11, paragraph 13. And annexure A by 2 may kindly be looked into. When my turn comes, I will place my.
अच्छा, you come to paragraph number 11. Let us first come to the counter affidavit, paragraph number 11.
11.
Hmm.
May I read to it?
Please.
That the averments made in paragraph 12 and 13 of the writ petition are not at all correct, hence denied. It is humbly submitted that the disciplinary proceeding number 2 of 2007 on the charges of improper maintenance of court diary, liberal grant of adjournments in civil cases, hasty disposal resulting miscarriage of justice, irregular in imposition of fine in the mobile court, and passing suo motu bail order in non-bailable offences was initiated against the petitioner. On consideration of the inquiry report in the said disciplinary proceeding, the court in their meeting dated 30/11/2010 were pleased to caution the petition to be careful in future. It is true that the petition had been granted with all normal service benefits thereafter, and he was allowed to continue in the service after his first review on attaining the age of 50 years. The petitioner's misconception that after passing the first review on attaining the 50 years successfully, he had accrued a right to continue till this normal age of superannuation is baseless and cannot hold good in the eyes of law. Rule 44(2) of the OSJS and OJS Rules 2007 prescribes that an officer is to be subjected to review when he is about to attain 50 years, 55 years, and 58 years. And in each review, the consideration prescribed for the purpose remains the same. The review committee had thus sufficient ground and reasons to award the petitioner with the punishment of premature retirement, having taken all aspects into the consideration. Your Lordship, kindly, the compulsory retirement is not a punishment, but here the counter affidavit the punishment of premature retirement. Your Lordship, kindly.
Now we come to page number 175.
175.
Some of the glimpses of the self-acclaimed acclaimed brilliant service career of the petitioner as narrowed below for kind reference.
175. Internal page 7 mile. Had in-court disclosure and envious.
Some of the से जो last line टा अछि तापर A B C अछि.
A B C D.
हाँ से पढ़न्तु गोटे.
A.
आपण को brilliant service career रो से reply देइछन्ति पर.
During the initial 5 years of service, the petitioner had 4 average ratings in his CCRs.
This is one of the brilliant. Yes, next.
In the year 2007, DP number 2/2007 was initiated against the petitioner for improper maintenance of court diary, liberal grant of adjournments in civil cases, hasty disposal resulting miscarriage of justice, irregular in imposition of fine in mobile court, and passing suo motu bail order in non-bailable offence, wherein he was cautioned to be careful in future. In the 2009, the night watchman of the court of the civil judge Jharsuguda had alleged that the petitioner had made some aspersions on his caste and used some filthy words for which he felt insulted. D. In the year 2015, the District Bar Association of Baripada had boycotted the court of the petitioner who was functioning as the CJM Baripada at that time, alleging against his unruly behavior, unfair practice, and non-supply of a cause list to the Bar Association of Baripada. E. Allegations were received against him during his tenure as Additional District and Sessions Judge, Barampur, Ganjam, regarding pronouncements of judgments by manipulating, inserting words in the depositions of sessions cases as well as miss cases, calling the advocates to his chamber as well as residence for arranging women and money for granting relief and misbehaving with advocates in the open court. F. Another allegation of receiving cash and kind through two advocates for passing favorable orders awards in MSc cases was also received against the petitioner during his tenure as ADJ Barampur. Should I continue, Madam?
Yes.
14.
They have
That
stated that vigilance report who has next paragraph also you read.
that in reply to the averments made in paragraphs 18 to 20 of the writ petition, it is humbly submitted that the punitive order of premature retirement of the petitioner on the basis of allegations to meet some ulterior or ancillary motive as alleged by the petitioner in these paragraphs is misconception of facts. It is humbly submitted here that the decision of premature retirement of the petitioner has been taken not only on the basis of allegations but also after assessment of CCR's personal file, vigilance report, overall performance, outturns, past service records, as well as other confidential reports. No ulterior motive or any vested interest has ever been involved in the premature retirement of the petitioner. Rather, the same has been made to safeguard the public interest and to accelerate the dispensation of justice in the state. Hence, the order of premature retirement passed in favor of the petitioner is just, proper, and has been made in accordance with the rules in vogue.
So what do you say? You see that what is the allegations against you? What has been done?
My lord.
How the DP has been instituted?
My lord.
And the full court
I have
perused your CCR, personal file, vigilance report, all your performance, everything has been taken into account.
No,
and therefore it was decided that no, it would not be proper to extend yours. So that is how the order was passed.
Now, as regards the DP, the matter relating to the 2002 has been initiated as DP in the year 2005, and in the 2000 it took 8 years, and that is in the year 2010 this DP proceeding was concluded, and for that I have also suffered, and I was not made any.
No, so many things are to be taken into account when this 50, 55, 58. These are you are to cross it, and to cross that the so many things are taken into. It's not that only that particular DP. So when this is your conduct throughout your service career, average in first 4, then this DP, then this complaint against by the bar members, then the allegation of corruption, vigilance report, and so many things have been taken, and the full court took a decision that will not extend.
In my kindly have a glance at my rejoinder. I have given all the allegations, the reply to the allegations. Kindly have a glance at my rejoinder. At page 190, it starts with 192.
Just a minute. Rejoinder affidavit kya hai? Rejoinder affidavit kahan par hai? Rejoinder affidavit kya file kar legi?
Rejoinder has been filed on 11/9/2023.
11/9.
Mile.
हाँ अच्छी.
Mile.
এটা দেখি না এই যে সিরিয়াল দউছেন
ইত্রে আছে কিন্তু সেত্রে নাই.
Mile.
ইন্ডেক্স রে নাই.
index
running page.
Hello.
This 190.
Page number CD লিখেছি but page number mention. Yes.
Mile. 193, paragraph 4, mile. That it is most humbly submitted that the impugned compulsory retirement is a glaring violation of the judgment passed by this honorable court, high courts, as well as the honorable appeals court. The petitioner has placed several such case laws in counter affidavit that the same are not disputed. As such, the alleged compulsory retirement is not an innocuous administrative action, rather it is punitive, passed for collateral purposes, and it is a camouflage punishment, and hence not sustainable in the eyes of law. that the aforesaid counter affidavit is not substantiated with any valid documents for which it is a superfluous statement and is liable to be turned down at the threshold. The allegations made in the counter affidavit are vague and afterthought. At no point of time there was any inquiry in respect of the aforesaid outrageous allegations at the instance of the Honorable Administration. As held by the Honorable Supreme Court in a number of decisions, honest and upright judicial officers are very often incur the wrath and displeasure of the aggrieved advocates and unscrupulous litigants, and it is the solemn duty of the honorable courts to protect such types of honest and upright judicial officers. That the petitioner is ever ready to meet any such allegations in the event they are placed before this honorable court at this stage. The petitioner relies upon the principles enunciated by the Honorable Supreme Court in the case laws such as State of Uttar Pradesh versus Chandramohan Nigam and others reported in such and such, also State of Jammu Kashmir versus Rajendra Kumar. I will cite it. That paragraph 7, that in reply to the averments made in paragraph 4 and 6 of the counter affidavit, is only submitted that the entire career graph of the petitioner, that is the yardsticks prescribed by the Honorable Court and achieved by the petitioner, is available with the Honorable Administration, which should have been annexed with the counter affidavit for judicial scrutiny. However, the petitioner has filed the relevant information in a tabular form with reference to the personal copies of the CCR submitted by him to the Honorable Administration, which show that the petitioner has achieved more than the yardsticks prescribed by this honorable court as compared with that of his contemporary incumbents. It is humbly submitted that the petitioner disposed of more contested cases as compared with his counterparts, which became a formidable factor to promote him to the post of selection grade district judge. Copy, I have annexed copy. The Lordship kindly have glance at the annexure 9 at page 205. All these things are graphically from the inception of his career. I have given all those things, documents. Your Lordship. This outturn of Sri Sanjay Kumar Sahu, internal page 14, 205, annexure 9. The yardsticks, those are the yardsticks that his performance is not shortfall of any yardsticks, as stipulated by this honorable. Then may I permit you to continue?
Yes.
Paragraph 8 at page 195. That in reply to the averments made in paragraph 7 of the counter affidavit, it is only submitted that at no point of time the petitioner during service period was intimated about any adverse entry made in his CCR.
No, what is the scope of a judicial officer? Under what grounds a premature retirement can be challenged? What is the scope of judicial review in that case? That what we are to see, that if an order has been passed, to what extent we are to see that yes, full court has passed the order, and accordingly, ultimately, governor has issued this. So, where is the scope that in this is the particular circumstances under which we can interfere, and that your case comes within that category.
One of the
first tell us that what are the citations you are
yes, I will
just place in that way. Because there are so many allegations, there are so many reports against
allegations. Those allegations, particularly I have DP as I will tell, and
that has been noted. Average performance, DP finding, bar members complaint, vigilance report. So many things are against you, and all those things are taken into account while passing that order. So if you want to interfere with that, the full court has taken not a correct decision, then and this order has been passed by the governor. So you are to satisfy that in the scope of this judicial review, in a writ petition, under what circumstances we can interfere? What are the scope? And so you are to.
As regards the allegations in the counter affidavit, that particularly may I place one paragraph only regarding
so it's not a fact that you have been given 4 average in the first 4 years.
My average marks have been given.
Yes, your CCR entry is average.
Yes.
We are exactly telling you, is it not correct that in that disciplinary proceeding, this order was passed against you?
Only
so all the council, these are the all the limbs of
cumulative
that. It's a cumulative effect which has been ultimately resulted in passing that order. So you are admitting everything that yes, average mark is there. This is the done. So vigilance report is
No
there.
vigilance proceeding has been made by your lordship.
You mean to say that vigilance proceeding in the vigilance court or what? That are you aware that there is a how these things are going is to be if something allegations is made, that how it is to be the inquiry is to be made. It's a confidential matter and report
This
is
is
to
a
be present.
confidence, my lord. The state government has particularly, your lordship kindly have got page 12. State government has particularly asked, is there any vigilance proceeding against the petitioner?
No, the only question, as my lord has asked you, what is the scope of reviewing the order?
One of the citations I would cite.
You saw that.
Yes, my lord, the Honorable Supreme Court has held that once a person or a judicial officer or a servant is public servant is promoted, then past entries, if any adverse entries may not be taken into account, and even may be permitted to show.
No. If you are right in at the age of 50.
My lord.
You are right.
You are right. But thereafter, within this 5 years career, other things happened that was taken into account, coupled with other things which have been not maybe that it was at that point of time you crossed that hurdle. But at the 55, when some further allegations came against you, they, along with these other earlier orders that were taken into account for which this order was.
My humble assumption is that in the year 2021, I was promoted to the selection grade. And in the year 2020, just after 1 year, I was found unsuitable. And it is, my lord, from there counter, your lordship kindly have, I am taking to the counter
No, the review for 50 years, 55 years, and 58 years is not for that particular year or for a day. Review is taken in totality of the service career of the officer. Otherwise, had it been a case of only day, how can we take it?
Kindly have a glance at page 180. Kindly have a place of 180 in their the notification, recent notification done to 19 they have given.
To where?
180.
180.
In their annex, their annexer A by 2 of their counter. What is the criteria, my lord? Page 12, 180, paragraph 6, my lord. The criteria to be followed by the committee in making the recommendation would be as follows. Government employees whose integrity is doubtful will be retired. Government employees who are found to be ineffective will also be retired. The basic consideration and identity of such employees should be fitness, competence of the employees to continue in the post which he is doing. C, that is vital for the petitioner. While the entire service record of an officer should be considered at the time of a review, no employee should ordinarily be retired on the grounds of ineffectiveness if his service during the preceding 5 years or where he has been promoted to a higher post during that 5-year period, his service in the higher post has been found satisfactory.
Then
this is the provision. So consideration is ordinarily to be confined to the preceding years or to the period in the higher post. In case of promotion with the period of 5 years, only when retirement is sought to be made only on the ground of ineffectiveness. So this provision is particularly glaringly violated while passing the impugned order. And moreover, the previous notifications also, your lordship kindly have may be permitted to have a glance at page 144, 150, 151, Annex 3, my lord. My humble assumption is that even the notifications, the circulars made by the government and by this honorable court, they have been glaringly violated. May I permit it to make? Your lordship kindly have this page Annex 3 at page 151.
Yes.
What are the provisions? What are the circulars? And I will cite the decisions also.
We'll take up, Mr. Misra will take up tomorrow.
Madam. Oblast.
କାଲିକି ନେଇ ଆସିବ ଏଇଟା along with other matters.
Three memos arising out of the same trial. Three memos, three appeals arising out of the same trial. Minor.
appeal ତ ରେଗୁଲାର ଆମର ଆସାଇନମେଣ୍ଟ ନାହିଁ ଯୋଉଟାକ 7 ବର୍ଷରୁ ସେ ଅଛି ତ 7 years ରୁ above ଯୋଉଗୁଡାକ
Detention.
ରହିଗଲାଣି ସେଇଗୁଡାକ କେବଳ that the other court may must be dealing with fresh admission.
Weekly list item number 1.
My lord, on behalf of Chandana Tripathi, out of station. କାଲି ଆସୁ ବୋଲି କହିଲେ। ଏଇଟା
It is special notice.
Fine. ଏଇଟା ପୁରା ପାଠାଡ ହେଇଥିଲା ଆଜି କି ଆସିବାର ବି ଥିଲା
ବାହାରକୁ ଯାଇଛନ୍ତି ସେ କାଲି ଆସିଥିଲେ ସେଠୁ ମୋର
ନାଟା ବି ଭୁଲ ଲେଖା ହେଇଛି
କୁହାଯାଇଥିଲା କାଟିବା ପାଇଁ ପଣ୍ଡା କୋର୍ଟ କୋର୍ଟ
ନା ସେ ମିସେସ୍ ଚନ୍ଦନା ପଣ୍ଡା ଲେଖା ହେଇଛି ଭୁଲ
ଥିଲା ଏବେ ତ୍ରିପାଠୀ
ଏଟାକୁ କଣ କରିବା ଆଜ୍ଞା ନାଇଁ ନାଇଁ ଠିକ ଅଛି ଏଇ ଯୋଉ ପଣ୍ଡା ତ ତ୍ରିପାଠୀ ମିସେସ୍ ଟା ପୁଣି ରହିବ ନା ନାଇଁ ମିସ୍ ତ୍ରିପାଠୀ ଏଇଟା ଆଜି ପାଇଁ ସ୍ପେସିଫିକ ଅର୍ଡର ଥିଲା ତ ଲିଷ୍ଟ ପାଇଁ
ପାଠାଡ ଥିଲା
ହଁ ଟପ ଅଫ୍ ଏତେ ଜିନିଷ ଥିଲା ତାକୁ କେମିତି ଆଣିନଥିଲା ଦିଅ ଦେଖ କଣ ଅର୍ଡର ଥିଲା This matter, top of the hearing,
ଏଇଠି ବି ଅଛି
Prisoner's petition for engagement of earlier engaged counsel and for early swanson. Sujit Kumar Gupta. Satyanarayana had been engaged by swanson. He is advocate की जानी चाहिए कि
ना
ये
सुजीत कुमार गुप्ता की हम जाने
Sujit Kumar Gupta is appearing before this court. He was in
जानी उठ दी तो ना
ना अभी शिमला वाले जान
no sir.
नहीं maybe
District court he is there.
District court
He is there in district court.
STM
अच्छा ये कटक रो
आगे गुप्ता ମୁଁ କହିଦେବି ଆଜ୍ଞା ଇଣ୍ଟିମେଟ୍ କରିଦେବି
अच्छा ये ठीक है फोन नंबर टा ठीक है लिखी नहीं देखिले ट्राई कले नंबर छी
And his name appears in the
नहीं
name नहीं सरकारी वकील से जो
सरकारी उत्तर लिखते हैं किंतु से
private
94 लिखिले मिस्टर लिख 94373 77 667 हरिबंधु विश्वास हरिबंधु विश्वास फोन नंबर भी भूल गई कौन बोल नहीं नहीं सी लिखुची let us read that once again लिखुची जे मु देइथिली सुजीत कुमार गुप्ता
ପୂର୍ବରୁ ଅଛନ୍ତି
हाँ पूर्वरु अच्छा
ତେଣୁ ତାଙ୍କ ଦ୍ୱାରା ବିଚାର କରାଇବା
देखा जी
ଫୋନ କରୁନା
अच्छा सीआरएल मोर अपील सरकारी वकील द्वारा करा जाइथिला ए पर्यंत ना मोर बेल होई पारछि ना विचार शेष करा जाउछि
flag A ରେ ସେଟା flag A ରେ ସେଟା
एटा एटा लेटेस्ट
ଏଟା latest flag B
हां फ्लैग बी टा लेटेस्ट तेणु मु जणे सरकार चाहूछि सरकार
ताले हमें दबा will engage
सत्यनारायण मिश्र तो अछंती हम एंगेज
हम engage କରିଛି ତ
वेयर इज मिस्टर
last time probably we were engaged
ତାଙ୍କୁ ଇଏ କରିଛନ୍ତି ହାଇକୋର୍ଟ ଲିଗାଲ ସର୍ଭିସେସ୍ ଅଥରିଟି ଆମେ କରିନୁ
in that order
ହଁ
27
27 ଟିକେ ତାଙ୍କୁ ଟିକେ ଡାକିଲେ ସତ୍ୟନାରାୟଣ ମିଶ୍ର ତାଙ୍କର ଗୋଟେ କଣ 1 2 3 4 ଅଛି ନା କଣ ଇଏ ବୋଧେ ସେ 4 ନମ୍ବର ହେଇଥିବେ ମତେ ଲାଗୁଛି
ଇଏ ଆପଣ ମାଇଲଟ ଆପଣ
ଟିକେ ଦେଖନ୍ତୁ ଇଏ କରି
ଦେଖୁ ଆଉ ଟିକେ
ନେକ୍ସଟ ମ୍ୟାଟର
Item number 2.
My lord, imprisonment for life and fine of rupees 5,000 in default manner arrive for 1 year more. Here, my lord, offense under section 302 of the IPC and this present appellant is the son, and deceased is his father, old father, my lord, and his elder brother is the informant in this case, and he is in custody, my lord, since 5/8/2011. Till that date, my lord, he has not, uh, my lord, released on bail, either on interim bail or right.
Final form bill. ନହେଲେ କୀର୍ତ୍ତନ ବହି 6/8/2011 ପୁରା through out ଇଏରେ କଷ୍ଟଡିରେ ଥିଲା.
Yes, my lord, he has not released on bail during the trial.
Produced in court. Yes, produced in custody, produced in custody. Right. So, ହେଲେ ଆପଣଙ୍କର 13 ବର୍ଷ ହେଇଗଲାଣି.
13 ବର୍ଷ ସମ
13 ବର୍ଷ ସମ
ଆଜ୍ଞା।
କଣ ଆଗରୁ ତ ବୋଧେ ମୁଭ୍ କରିନାହାନ୍ତି, କଣ ଆଲିଗେସନ କଣ ଥିଲା?
Allegation, my lord, that PW6 is the informant come direct eyewitnesses to the occurrence along with his wife PW11. My lord, they were
PW6 and PW11 are the two eyewitnesses.
Yes, my lord. Thereafter, my lord, other witnesses came. They are the co-villagers, my lord, co-neighbors.
Who is the doctor?
Doctor, my lord, PW18. And doctor indicates, my lord, there are, my lord, injuries, 9 external injury, and my lord, 2 internal injury are there. And this injury, my lord, that judgment,
Forehead, neck. You come to that paragraph number 2
my lord,
of the that evidence. First wound is on the forehead, second wound is on the neck, third wound is on the neck, fourth wound neck, fifth wound neck, sixth wound neck, seventh wound neck, eighth wound abdomen, ninth wound hand.
and right hand. 9 injury on right hand.
କଣ ପାଇଁ ଏମିତି ବାପାଙ୍କୁ ଏମିତି ନୃଶଂସ ଭାବରେ ହତ୍ୟା କଲେ, କଣ କାରଣ କଣ?
Apart from that, this petitioner killed his father. Deceased is the father.
Deceased is the father.
Father of this appellant.
Because he did not agree to give the marriage
with that lady, namely Bijuli Hoi of that village, because this present appellant wanted to marry
one Bijuli Hoi.
But the
ବାପା ରାଜି ନଥିଲେ.
For that reason, my lord, that this occurrence occurred as per the prosecution case, my lord, prosecution allegation.
For the petition and counsel for the state, the Land and Council for the petitioner submit that the petitioner is in judicial custody since 6/8/2011, and as such, he has remained in custody for more than 13 years. And he has not yet been given, and therefore there is no chance of public hearing. And the bail application of the petitioner may be favorably considered. Land Council for the state oppose the prayer for bail and place the evidence of PW6 and PW11, the two eyewitnesses to the occurrence, also the evidence of the doctor bracketed PW18 who conducted postmortem examination over the dead body of the deceased and noticed as many as 9 external injuries on different part of the body of the deceased, and the cause of death has been opined to be shock and hemorrhage as a result of the cause injuries. The Land and Council for the state further submitted that the petitioner, the deceased was the father of the petitioner. Considering the submission made by the Land and Council for the respective party, the nature of evidence adduced by the eyewitnesses, so also the evidence of the doctor, the manner in which the crime has been committed, while not inclining to release the petitioner on bail on merit, but taking into account period of detention of the petitioner in judicial custody and also the law laid down in the case of Lekki versus Swanshu, they are inclined to release the petitioner on interim bail for a period of 3 months. But we report to the court. Yes, next.
Okay.
Item number 3.
Subtenant, Mr.
So you are engaged by the legal so are you aware about it or not?
No. Letter जाएगी?
Letter की बात था आपको?
তাহলে ଅନ୍ୟ ଆର ସତ୍ୟନାରାୟଣ ମିଶ୍ର
ନାଇଁ ସେ ଯୋଉ ଇଏଟା ଦେଖି ଏଇଟା ଫାର୍ଷ୍ଟ ମ୍ୟାଟର ସିଆରଏଲ 62 ଏଇଟା
ହଁ 4
Mr. Satyanarayana Mishra, advocate, has been
another Satyanarayana Mishra is there, man.
4 ଜଣ ଅଛନ୍ତି ତ
My serial number is at 6.
6 or 4?
That list. I am Satyanarayana Mishra 4, but in that list I am numbered serial number 6.
But normally ଏଟାକୁ ଆପଣଙ୍କୁ ତ mean କରାଇକି ଦିଆ ହେଉଛି.
That legal at list मेरा.
Superintendent so necessary action. और the exit तार उड़े किसी नथी होगी तो intimation दियंती ना
निश्चित କିଛି ଦିଆ ହେଇନି.
ସେମାନେ engage କଲେ ଠିକ ଥିବ but
ଦିଆ ହୁଏ ଫିଜ୍ ବାବଦରେ ସବୁ. Secretary Odisha High Court Legal Services.
अच्छी फाइल डाल थोड़ा कौन अच्छा
Admit share Compulsory. No.
Every year with the High Court Legal Services for country. Just the issue to go through. The point is from student and
Let it be. Not next week. I will be prepared.
तो ସେଇଥିପାଇଁ ଅଣା ହେଲା ସବୁ ଅର୍ଡର ସେ ଯେ ପୁରୁଣା କେସ୍ ଗୁଡାକ ମାନେ
paper book are ready because noting is there, my lord.
You
3.
received the paper book.
Yes, ma'am.
Mr. Deepak Kumar Saul is present. Item number 3. And submits that he has not received a copy of the paper. The copy of the paper book supplied to him in court today. Matter will be listed next week. No?
Oh, bless. In hearing list.
It order
Hearing.
it used to be in the hearing list.
Oh, bless.
Number 4.
Your Lord, petitioner granted interim bail for a period of 3 months. And in the meantime, already been surrendered. I have applied the copy, my lord. Next day, I will produce the same, my lord.
You have instruction that he has
Surrender.
Okay. Land counsel for the appellant submits that after appealing the interim bail period as per order dated 15/5/2024, the appellant has surrendered in the trial court and matter may be taken off 1 week after to produce the surrender certificate. This matter in the week commencing from 11th of November 2020. Yes.
Item number 5.
The purpose में आस्तिला पेपर बुक रिसीव करना भी एक कुछ मिलना है ये तुम जानते हैं
सुभाष चंद्र प्रधान back कर देंगे
engagement इधर भी चाहिए आप जो ଲେଖିଥିଲା ଯେ ମତେ ଗୋଟେ advocate engage କରାଯାଉ ଏବଂ accordingly ସେ ଅଫିସ ବୋଧେ ଏଟା engage କରିଛି legal DM
चंद्र
Starting of 2016 ଗୋଟେ ଓକାଲତନାମା ଅଛି ଏଟା legal aid ଜରିଆରେ ଆସିଥିଲା ହଁ ଚିଠିଟା ବି ତ ଅଛି Office of the High Court Legal Services Committee ସୁଭାଷ ଚନ୍ଦ୍ର ପ୍ରଧାନ
सुभाष चंद्र
been engaged by the High Court. High Court Legal Services Committee, but he is not present. The criminal appeal is of the year 2014. Accordingly, the court engages so and so as the
ये वो तो interview
the copy of the paper book applied to him. Matter to listed next to
सुभाष प्रधान तो ऐसा कि बोलते MSc ट्रेक वाला It's not in criminal case.
लिस्ट टा दउछनी ना से मगा ହେଇଥିଲା ବାହାରୁ
ସେଥିରେ
Item number 6.
ପ୍ରିୟବ୍ରତ ସିଂ ମାନେ ଆମର ଇଏ ତ
पीआर सिंह से
ହଁ ଇଏ ତ ଆସୁଛି ଆଉ।
हैं सी पीआर ये प्रियव्रत ये रहता भाई ना कौन जो एक्सपायर रहता ना
ଆଉ ସେଇ ଯୋଉ ସିଂ ମାନେ ଇଏ ସିଂ ନୁହେଁ ଆମର ଯୋଉ
प्रिय प्रिय रंजन सिंह से
ଇଏ ହଁ ପ୍ରିୟ
आर तांको भाई हला प्रियव्रत सिंह सी बोलते मोस्ट वाले एक्सपायर करी ना मते
Item number 7.
Item 7 may be resolution. Last of it
ଦିଆହେଲା।
7 ନମ୍ବରରେ କଣ ଲେଖିଲେ? କଣ ଆସିଲା? ଆଇଟମ ନମ୍ବର 7 ଲେଖନ୍ତୁ। Period.
Well, the appellate is convicted.
Please use the mic.
My lord, the appellate is convicted under section 301 and 201 IPC.
What is
and
his prayer for interim bail?
interim bail for he want to sell his property, and he is a retired army officer, and his pension is held up last 11th 11
No.
November 2023, my lord,
Have
due
been
to the
found guilty under 302.
my lord,
And you are a retired
army colonel, my lord.
army officer. So what is the allegation against you?
Allegation, my lord,
My lord,
and
boiled his
deceased-
wife into small pieces, mixed the same with Nimile solution and kept in 22 steel container of different size. And also kept 2 bags bone of her legs without flesh in the plastic bucket, my lord, in the bathroom.
Different tipping boxes.
My lord, he is under custody in 11 years and 3 months, 15 days, my lord. And
No, paper book is ready.
my lord,
Get you if you want to argue the matter, you can argue. Are you ready today?
today I'm not.
Get ready. Get ready. Next week we can take up the hearing. Okay.
My lord, 2 weeks, my lord.
IA number so and so, IA number so and so. These are 2 bail application and 1 is for interim bail. After hearing the learned counsel for the appellants, also the learned counsel for this bail, in view of the nature and gravity of the so and so, we are not inclined to release the petitioner on bail. However, since the petitioner is stated to be in actual police for more than 11 years, and he was aged about 77 years when the judgment was pronounced in the year 2020. And the paperwork has already been prepared. The matter be added to the hearing there. You want it 11th or 18th?
My lord,
11 ତାରିଖରେ ଆସିବ ନା 18 ତାରିଖ ନଭେମ୍ବର ମାସରେ? ଆପଣ 2 ସପ୍ତାହ ସମୟ ମାଗିଥିଲେ। ତ 2 ସପ୍ତାହ ପୁରୁଛି 11 ତାରିଖରେ। 11 ଆସିବ ନା 18 କେବେ ଆପଣ ଚାହୁଁଛନ୍ତି? 18 18th of November 2020. Get ready for hearing. 18th November 2020. Yes.
That's optional.
Which number? Item
1.
Which one?
Item 1, my lord. Jeta Satyanarayana Mishra jeta.
Acha, you are. तो आपणकर ना कज लिस्ट रे आसुची आसुनांती अच्छा वर्तमान पेपर बुक रेडी गलानी 2009 रो जेल क्रिमिनल अपील 15 वर्ष पास गलानी पेपर बुक आपण रिसीव करिवेनी कोन आमे सेति पई तो कोर्ट रो कोन करा दियो कोर्ट आपण कोर्ट
नेक्स्ट वीक माइनर आई विल
कोर्ट रो ऑर्डर बल रे आपण को लीगल सर्विसेज अथॉरिटी आपण को एडवोकेट हिसाब रे एंगेज करले आपणकर ना कज लिस्ट रे आसिला ତେଣୁ ଆପଣ କହିବେ ପେପର ବୁକ୍ ପାଇନି 2009 ମ୍ୟାଟର ସେଇ ଗ୍ରାଉଣ୍ଡରେ ତ ଆର୍ଜନ କରିହବନି ନା।
My lord, next week I will try and receive the paper, but I never take any time, my lord. Next week.
तो ଏଇ ପେପର ବୁକଟା ଦେଲେ ରିସିଭ କରିକି ନେଇଯାଅ। ହଁ ଆପଣ ପେପର ବୁକ୍ ଆଜି ରିସିଭ କରିଦିଅନ୍ତୁ, କମିଂ ୱିକରେ ଆସିବ ହେଲା, ଟିକେ ଅପେକ୍ଷା କରନ୍ତୁ। ଦେଖନ୍ତୁ ସତ୍ୟନାରାୟଣ ମିଶ୍ର is present and submits that he has not received the paper book. The copy of the paper book supplied to him in court on foot of this matter next week, that is post November 2020, under the headings of A. 4 तारीख रे आसीबो, you get ready, just paper book receive करनी।
Other name may be deleted.
अच्छा, the name of Subhasri Manvi shall not be reflected in the ये ତାଙ୍କର ନମ୍ବରଟା କଣ 4, ଆପଣଙ୍କର ନମ୍ବର କେତେ?
Sir, ଖାଲି ସତ୍ୟନାରାୟଣ sir ଲେଖିବେ।
ଦେଖନ୍ତୁ 4 ଲେଖନ୍ତୁ। Okay, next.
Item
First item
8 बोलते ना कहते 14
ସସ୍ମିତା ନନ୍ଦ ଅଛନ୍ତି। ଅଛନ୍ତି। ପୁଣି ମୋ ପାଖକୁ
ସବୁଦିନ କରିପାରିବେନି କିନ୍ତୁ ସବୁଦିନ କରିପାରିବେନି କିନ୍ତୁ କରିବେ।
କିଏ ଅଛନ୍ତି କୁହନ୍ତୁ? ନିହାତି କରିବେ। You are ready? ଦିଅନ୍ତୁ।
Item number 16.
My lord.
This appellant before your lordship has challenged
Yeah, please place your.
the appellant has challenged the judgment and order dated 12/27/11/2009 passed by the ad hoc additional my lord. And I have prepared a small date set.
302 life and vision. So you come to that FIR. Let us know the prosecution case. Page number 47.
निवेदन कारण है मु श्रीदेव जेना पिता गोपी जेना ग्राम
Swadap Jena is PW 10. The ward member of the
ward member. He has not seen the occurrence, but
please. Please କରନ୍ତୁ।
ଆମ ଘର ପାଖରେ ରାଇ କିଶୋର ଜେନା ଆଉ ନିତ୍ୟାନନ୍ଦ ଜେନା।
ରାଇ କିଶୋର ଜେନା ହେଲା appellant।
No, my lord. Appellant ହେଲା ରାଜକିଶୋର
ରାଜକିଶୋର ଲେଖା ହେଇଛି
ନାଇଁ ନାଇଁ ସିଏ
ରାଜକିଶୋର
ଏତେ ଭୁଲ ଲେଖିଆ
ପେପର ବୁକ୍ ର ଫ୍ରଣ୍ଟ ରେ ଲେଖା ହେଇଛି ରାଜକିଶୋର ଇଜ ଇଟ୍ ରଙ୍ଗ ନୋଟିଂ ହେଇଛି ନାଇଁ ଜଜମେଣ୍ଟ ରେ ତ ଅଛି ରାଜକିଶୋର ଜଜମେଣ୍ଟ ପେଜ ନମ୍ବର 4
Raikishore then.
ରାଜକିଶୋର
Raikishore is the appellant.
ରାଜକିଶୋର ଇଜ appellant
ରାଜକିଶୋର ମାଇଲର
Raikishore.
ଲେଖା ହେଇଛି JCRL ରେ ଲେଖା ହେଇଛି ରାଜକିଶୋର
JCRL
ଜଜମେଣ୍ଟ
Raikishore.
that's a wrong ରାଜକିଶୋର is
Even
the
accused statement is Raikishore.
ଜଜମେଣ୍ଟ ରେ ଲେଖା ହେଇଛି ରାଜକିଶୋର
ଜଜମେଣ୍ଟ ରେ
ଲେଖା ହେଇଛି
ନା ତ Raikishore ଲେଖା ହେଇଛି।
ଆପେଲାଣ୍ଟ
ହଁ ରାଜକିଶୋର ତା ନାଁ ହଉଛି ରାଜକିଶୋର ଭୁଲ ପଜ ଲିଷ୍ଟ ରେ ପ୍ରିଣ୍ଟ ଭୁଲ ଅଛି ହଁ ଆପେଲାଣ୍ଟ ତାର ଘରୋଇ ଘଟଣାକୁ କେନ୍ଦ୍ର କରି ଏକ କତା ସାହାଯ୍ୟରେ ଅଛି
ପାରା 2 ରେ ରାଜକିଶୋର ହେଇଯାଇଛି।
ବେଙ୍ଗ ଜେନାର ବେକ ମୁହଁକୁ ହାଣି ମାରିଦେଇ ଅଛି ସେଇ ସମୟରେ ତାର ଝିଅ ହାତ ଧରିଲେ ମଧ୍ୟ କିଛି ଶୁଣିଲା ନାହିଁ ଏଠାରେ ପ୍ରକାଶ ଥାଉ କି ଏହା ପୂର୍ବରୁ ସେ ସ୍ତ୍ରୀକୁ ଅନେକ ବାର ମାରପିଟା କରେ ଏଣୁ ବିନୀତ ଅନୁରୋଧ କରେ କି ଉକ୍ତ ଘଟଣାର ତଦନ୍ତ କରି ଆସାମୀକୁ ଦଣ୍ଡ ଦିଆଯାଉ
So who are the eyewitnesses to the occurrence?
Well, nobody has seen the occurrence, but
PW12 is the eyewitness, the daughter of the accused minor. PW4 is the sister-in-law of the accused. PW6 and 7 are the mother and brother. But 4, 6, 7 they became hostile.
Just
only
all are
PW4
is the sister-in-law of the accused.
no PW4
hostile के है
PW4 6 and 7
PW6
4 6 and
7 hostile है
right
support की कला है कौन
PW12 the daughter of
only the daughter
PW
she has
daughter of the appellant and
the deceased Deepika Jena
supported okay and who is the doctor who
PW9
is the PW9
PM doctor
Dr. Sudhir Ranjan Naik.
So apart from the eyewitness evidence of that PW12, is there any other circumstantial recovery on an so?
PW10 has lost the affair after the incident.
All right, then you come straight to PW12.
Deepika.
PW12.
She was aged 13.
Yes, ma'am.
More than 12. Achha.
Okay.
More than 16 years.
No, on the date of examination, she was 13 years.
No.
About 14 years.
PW12 evidence.
Mandatory.
Page 76.
The position of witness number 12.
No, you just
come to 78.
Skip over those
come
things.
To straight 78.
76 ରୁ ଆରମ୍ଭ ହେଇଛି ତାପରେ question answer ହେଇଛି
78
78
The accused standing in the dock is my father.
Yeah.
Deceased Bengo Jena is my mother. The occurrence of this case had taken place about 1 year back. About 1 year back on a day at about 12 noon. My mother was cooking on the veranda of her house and I was sitting near her. And at that time, my father came to our house from below and told my mother to give meal, and my mother told my father to wait for some time. And on this, my father became angry and entered inside the house and brought a poturi and gave poturi blows by dragging my mother, holding her tucked. My father gave poturi blows on the neck, face, and head, and ear also of my mother. Seeing the same, I raised Hala, and my paternal uncle and auntie, elder father, some villagers came to the spot. Then immediately my mother died at the spot, and my father was standing there, and immediately my paternal uncle and some others tied my father by means of a rope. Prior to the occurrence, there was good relationship in between my father and my mother, but in the occasion prior to 2 months of occurrence, my father had assaulted my mother. I was examined by the police in this case.
Yes. Read the cross-examination.
Cross-examination defense. I left my study 1 year back. Among the sat was the headmaster. Business sir was our class teacher. I was examined by police on the same day of occurrence in my village at about 5 p.m. The Koturi Kata, by means of which my father had killed my mother, was lying at the spot, and police took the same from the spot, and I had seen the same. Apart from this, I cannot say as to whether the police had taken some other things from the spot. I am residing in my maternal uncle's house after the occurrence. My mousy is taking our care. I am abiding to my mousy. Case. Case.
Question पचरा हला एई केस बाबदरे माउसी तुमको किछि कहिवाकू कहिचंती की ना
ना मते
ना
किछि
उत्तर
कहि
होची ना ना मते किछि कहि ना
ना
हला then read out in my uncle's house.
In my uncle's house, my maternal grandmother, my mousy, and the 3 sisters and brothers are only residing and none else. After the occurrence, I have not stated about the occurrence to anybody except the police. Surya Ketu दिगरे
କେଉଁ ଦିଗରେ ଉଦୟ
ସୂର୍ଯ୍ୟ କେଉଁ ଦିଗରେ ଉଦୟ ହୁଅନ୍ତି ପଚାରିଲେ ଆନ୍ସର ପଶ୍ଚିମ ଦିଗରେ. The house of my elder father Babaji adjoins our house in one side, and the house of my paternal uncle and adjoining our house on the other side. The family of my paternal uncle Minna economy of my paternal uncle Moina, his wife, his son aged about 5 years, and his mother. The family of my elder father Babaji consists of my elder father Babaji, his wife, and 2 sons
and
two daughters only. The house of Babana is
Basana.
house of Basuna is in front of our house, being intervened by village conducts.
village danda.
Village danda. The family of
Basanta.
Basanta
No, Basana. Consists of Basana himself, his wife, and two brothers and
his mother. At the time of occurrence, my father became angry, but he did not utter any obscene words against my mother. I cannot say the day of the occurrence. Bharat, the school was open on the day of occurrence. On the day of occurrence, I had not gone to the school from this day. Even for one.
I left my study and did not attend school.
Of occurrence,
even
I
for
did
one
not
day.
go to the school as my mother told me not to go to the school. When my father assaulted my mother by means of cutlery, except me, no other person were present. The
other person came to the spot.
Came to the spot only
after hearing my
mother. My mother was cooking in a chai which adjoins our main house. I cannot say the direction of the chai where my mother was cooking from our main room. The pottery in question was about
1 cubit
in length. It was a bonka pottery. It was about 1.5 inch in height. The weapon of offense pottery had no wooden handle. When my father gave pottery blow to my mother, I was at a distance of about 5 cubits from my mother. I was sitting
outside the chali.
Chari. I did not raise any halla when my father
brought Koturi from our
brought Koturi from our house, but I raised halla when my father assaulted my mother by means of the Koturi.
I got down from the Pinda.
I got down from the Pinda and raised halla. The Pinda urgent sir Danda. I got down from the Pinda on seeing the assault to my mother caused by my father by means of Koturi. At the time of the occurrence, our kitchen was not smoky. The entire occurrence had taken place inside the child. My
Chari.
father had dragged my mother only 1 cubit to 2 cubits. I cannot say the number of Koturi blows dealt by my father to my mother. By the time the court by the time the court
Outsiders reached there.
outsiders reached
At
the
the spot.
my mother already killed. My father asked my mother to give meal, and at that time he was in
In
standing
standing
position. My Mausi has been deserted by her husband, and she is staying in my uncle's house. During the lifetime of my mother, my Mausi Rajani used to come to our house. It is not a fact that there was conflict in between my Mausi and my father for financial transaction. It is not a fact that prior to the death of my mother had sent me to my uncle's house under the care of my Mausi, and I was not residing in our house since last 2 years. It is not a fact that I am deposing falsehood in the court today at the instance of my Mausi. It is not a fact that my father has not killed my mother in my presence and that I am deposing falsehood. So,
So what is your submission challenging this evidence of PW2, who is none else than the daughter of the appellant and also the deceased? So why she would tell falsehood against you? PW12. PW12.
we will do it.
No, that child witness.
ସେଇ
Only
ଯୋଉ ଛୁଆ ଆପଣଙ୍କର ଯିଏ ଝିଅଟି ଆପଣ କଣ ବାହାର କରିଛନ୍ତି ଯେ ତାକୁ ଆମେ ଡିସବିଲିଭ କରିବୁ?
I have gone through the paperwork and plus the deposition of all the witnesses. Everybody has everybody has not supported the case of the
ଛାଡି ଦିଅନ୍ତୁ, ଅନ୍ୟମାନଙ୍କ କଥା ଛାଡି ଦିଅନ୍ତୁ। ସେ ତ କହୁଛନ୍ତି 3 ଜଣ ସପୋର୍ଟ କରୁନାହାନ୍ତି, 4, 6, 7 ହୋଷ୍ଟାଇଲ ହେଇଛନ୍ତି। ସେ ହୋଷ୍ଟାଇଲ ୱିଟନେସ ର ଇଏ କଣ ହବ, ଦ୍ୟାଟ୍ସ ଏ ଡିଫରେଣ୍ଟ ମ୍ୟାଟର। ବର୍ତ୍ତମାନ ଆମେ ଯୋଉ ୱିଟନେସ ଟିକୁ ଆପଣ ପ୍ଲେସ କଲେ ତାକୁ ଆପଣ କଣ ଜେରାରେ କାଢିଛନ୍ତି ବା କଣ ଅନ୍ୟ ସର୍କମଷ୍ଟାନ୍ସ ଅଛି ଯୋଉଥିରୁ କି ସେ ୱିଟନେସ କୁ ଆମେ ବିଲିଭ କରିବୁ ନାହିଁ? କାରଣ if law is very clear that if a particular witness, the number of witnesses is not that relevant, the quality of evidence it is relevant, and she is a witness who has been testified.
Yes.
And the presiding officer, after putting some questions on different aspects, was satisfied that she was giving rational answers. She was quite intelligent, and she has stated what she has seen.
Robustly faced the cross-examination.
Cross-examination, 2-3 ପୃଷ୍ଠାର cross-examination face କରି ଯାହା ବି କହିଲା କଣ ପାଇଁ ତାକୁ disbelieve କରାଯିବ? ଆଉ ଯଦି disbelieve ନ କରାଯିବ ତାହେଲେ ତା evidence ଟା ଯଦି acceptable ହବ, then ତାର evidence ରେ ଆସୁଛି ଯେ you are the person who killed your wife by dealing successive blows on neck, face, head, and ear. And this doctor who conducted postmortem examination, that is PW9, has also noticed that his evidence is at page 68. कम से कम 9टा इंजुरी से कट इंजुरीज देखिछन।
नेक फेस
प्रथम इंजुरीटा होची गोटे फोरहेड रे, द्वितीयटा होची आईब्रो रे, ତୃତୀୟଟା ହଉଛି nose, fourth also left maxillary, fifth is upper lip, sixth left mandible, then seventh is neck, eighth is left ear,
shoulder,
and last one is shoulder. These are all cut injuries, and because the weapon of offense is a sharp cutting weapon, as stated by the daughter PW12, ଏବଂ ସେ କହୁଛି ମଧ୍ୟ ଯେ my father gave cautery blows on the neck, face, head, and ear of my mother. So the doctor's evidence also indicates that the
Assault was
it
by the
was
cautery.
He examined the cautery which was produced before him. Paragraph 5 it is stated, and I opined that the cause of death of the deceased can be possible by the said weapon, that is cautery. এবং তার opinion হচ্ছে injuries are sufficient to cause death in ordinary course of nature. PM report has been proved.
Since the PW12, the doctor, although she is minor, but her evidence could not be avoided. It disbelief. My humble submission is it is admitted fact that her father has killed the mother. So it will be.
What is your defense be?
Culpable
homicide. Accused statement. ଆପଣ କଣ କହିଲେ?
ସବୁଠି ନାହିଁ କହିଛନ୍ତି କମ୍ପ୍ଲିଟ ଡେନିଆଲ।
ମିଛ କେସ୍ ମିଛ କେସ୍।
ହଁ କମ୍ପ୍ଲିଟ କୋଉଠି ବି କହିନି ସବୁଠି ମନା କରିଛି।
କମ୍ପ୍ଲିଟ ଡିନାଲ ଅଛି।
Now, my lord, 16 years he is in jail custody. So I pray for to convert 302 to 300 culpable homicide.
Once we are to give some, unless that case comes within any of the exceptions, that is culpable homicide not amounting to murder. That is 5 exceptions have been laid down. If we cannot you cannot bring the case into that, then the question of converting it to either 304 part 1 or part 2 does not arise.
The intention, no intention to kill her, his wife.
ଆପଣଙ୍କର ସ୍ତ୍ରୀ କୁ ମାଗିଲେ ଖାଇବାକୁ ଦିଅ, ସେ କହିଲା ଟିକେ ରୁହ, ଏତିକି ତ କହିଛି ଆଉ କଣ, କିଛି ପ୍ରୋଭୋକେସନ ଆଦେର ନାହିଁ.
No other has had whatever the PW12 said, that is final. No other has seen the occurrence or
ଘର ଭିତରଟାରେ ଆଉ କିଏ ରହିବ? ଆପଣ ଫ୍ୟାମିଲି ମେମ୍ବର୍ସ ରହିବେ, ଫ୍ୟାମିଲି ମେମ୍ବର୍ସ 3 ଜଣ ସପୋର୍ଟ କରେ ନାହିଁ, ବାକି ଝିଅଟା ରହିଲା, ଝିଅଟା ହୁଏତ ସେଠି ରହିଥିଲେ ବି ସିଏ ବି ସପୋର୍ଟ କରିନଥାନ୍ତା, କିନ୍ତୁ ଝିଅ ଯାଇକିନି ଯେହେତୁ ମାମୁଁ ଘରେ ରହିଲା, ତେଣୁ ସିଏ ଯାହା ଦେଖିଛି ସେ ବିଷୟରେ କହିଲା, ଏବଂ you have not brought out anything that she has been tutored to tell anything against his father.
A specific question has been denied by that. Intention is clear from the nature of injuries and weapon used.
No intent at the spur of moment and
spur of the moment, that's a different matter. ଭାତ ଆପଣ ଭୋକ ହଉଥିଲା, ଠିକ ଅଛି, ଭାତ ଆପଣ ଖାଇଲେ, ଆପଣ ସ୍ତ୍ରୀ କହିଲା ଟିକେ ଅପେକ୍ଷା କର, ଆପଣ ଯୋଉ ୱେପନ ଟା ଯାଇକି ଆଣିଲେ ଏବଂ ଯୋଉ ପାର୍ଟ ଅଫ ଦି ବଡି କୁ ମାରିଲେ, ଅନ୍ୟ କୌଣସି ପାର୍ଟ କୁ ମାରିନାହାନ୍ତି, କେବଳ ମାନେ ମୁଣ୍ଡ, ବେକ, ନାକ ଏଇଗୁଡାକର, ଆଉ ତା ଛଡା ଆଉ ତଳକୁ ଖସି ନାହାନ୍ତି। ତ ଏଇ ସର୍କମଷ୍ଟାନ୍ସ ରୁ ଆପଣଙ୍କର ଇଣ୍ଟେନସନ ହିଁ ଦେଖଉଛି ଯେ ଆପଣ ତାକୁ ମାରିବାକୁ ଚାହୁଁଛନ୍ତି।
ନାଇଁ ଆସଲ୍ଟ କରିଛି, କିନ୍ତୁ ସଡନ ପ୍ରୋଭୋକେସନ ସେ
ସଡନ ପ୍ରୋଭୋକେସନ କେମିତି ହବ କହୁନାହାନ୍ତି ଆପଣ, ଇଲାବୋରେଟ କରନ୍ତୁ।
Because he was hungry and when his wife said to wait for some time, he became angry and killed his wife without any intention.
No. Somebody is hungry and he is asking for the wife, and if we said that that is the provocation, then that would lead a bad precedent that everybody, whenever such a situation comes and you would kill, that is it's a grave and sudden provocation. ଆପଣଙ୍କର ରୋଷେଇଟା କରିବା ପାଇଁ ଜଣେ ରେଡି କରିକିନି ଜଣେ ସ୍ତ୍ରୀ ଲୋକ ରୋଷେଇ କରିବ, ତ ତାକୁ ହୁଏତ ସିଏ ପ୍ରସ୍ତୁତ ହେଇନଥିବ ବା କରୁଥିବ,
ହଁ ସେ ଯଦି
ସେଥିପାଇଁ
କହିଥାନ୍ତେ ଆମେ ଖାଇବା ଲାଗି ତମକୁ ଦେବୁ ନାହିଁ, ତମେ ଚାଲିଯାଅ,
ହଁ, that's a different
ସେଟା
matter.
ଏଇଠି ତ କ୍ଲିୟରଲି ସେ
Let's
ଅପେକ୍ଷା
say କହୁଛି ଟିକେ ରୁହ, that is the language
Yes.
used by the daughter, that ଟିକେ ରୁହ. ଟିକେ ରୁହ ମାନେ most likely either she is busy otherwise, that is why she was asking, or the food preparation is not complete, ସେଥିପାଇଁ ସେ କହୁଛି ଯେ ଟିକେ ରୁହ. ତେଣୁ ଏଇ circumstance ରେ ତାକୁ ଆଣି repeated blows ଦବା, 9ଟା blow, and that too on the vital part of the body, ଏଠି ଆପଣ provocation କଣ ଆସୁଛି?
It is not a normal reaction of a person.
Because of hungry, he became angry and used the cutlery blow successive also. So my prayer is, your lordship, if he
ଅନ୍ୟ ପଟେ ଏକ୍ସପ୍ରେସ କରାଇ ପାରିଥାନ୍ତା, ଜଣେ ହୁଏତ ଥାପଟେ ମାରିଥାନ୍ତେ କଣ, ଏଇ ଟାଇପ ର ମାନେ ଅଲଗା କଥା, but you are using a sharp cutting weapon and giving successive blows, and how this will come on a provocation?
already 16 years is in jail.
That's a different matter that state will consider. Obviously, yeah, there is a that after usually 14 years they used to consider in each case, keeping in view several aspects. तार conduct कौन अच्छी ये सब जिनस देखी कि नहीं, से recommendation हुए state को, तार board अच्छी समान consider करिए. We are not on that. We are on the that on merit of the case you are to say us. ଆଉ କିଛି submission ଅଛି ଆପଣଙ୍କର?
नहीं, only I pray for conversion.
Yes, Mr.
The PW12, the daughter of the appellant, my lord, his evidence is very clinching. Nothing is elicited from his cross examination also. And
look on
PW9.
All right, take down. The appellant Rai Kishore Jena faced trial in the court of London ad hoc additional session judge, fast track court, Jaipur, Jajpur, in city case number 27 of 2009 for offense punishable under section 302 of the Indian Penal Code on the accusation that on 25th September 2008 at about 1:30 p.m. village Unasa under Mangalpur police station in the district of Jajpur, he committed murder of his wife Bengo alias Sinia Jena. The London Trial Court had judgment and order dated 27/11/2009 found the appellant guilty of the offense charged and sentenced him to undergo imprisonment for life and to pay fine of ₹5,000 in default to undergo rigorous imprisonment for 6 months. The prosecution case in short is that on 25/9/2008, the appellant returned at about noon.
At 1:33.
12 noon or
At about noon.
Returned from the field and asked the deceased to give meal, but the deceased told him to wait for some time. Stop. At this, the appellant got angry and entered inside the house, brought a cautery, and dealt successive blows on the deceased on his neck, face, head, and ear. The deceased died at the spot, and the ये ଶେଷ ଦେବ କଣ ହବ? PW10,
The ward member of
the ward member of Mauja, Ponasam, name is Sesadev Jena, bracket PW10, lost the first information report before the officer in charge of Mongolpur police station, on the basis of which Mongolpur PS case number 91 dated 25/9/2008 was registered under section 302 of the Indian Penal Code against the appellant. Who is the IO in this case?
PW13.
13 last.
PW13. PW13, Prashant Kumar Majhi, the OIC of Mongolpur police station, after registering the case, took up investigation, and he came to the spot and found the dead body and held inquest over the dead body and prepared the inquest report exhibit 2. And then the dead body was sent for post-mortem examination to District Headquarters Hospital, Jaspur. And the IO bracket PW13 seized the bloodstain pottery bracket MO 1, which was used as the weapon of offense. Bloodstain pottery, which was used as a weapon of offense from this spot. As for seizure list, exhibit 1/2. So also the bloodstain earth, sample earth, bloodstain sari of the deceased in presence of the witnesses. The appellant was arrested and was forwarded to court. The IO made a query to the doctor, conducted post-mortem examination by sending the weapon of offense regarding possibility of the injury sustained by the deceased with such weapon, and the doctor opined affirmatively. The exhibits were sent to for Forensic Science Laboratory, Rasulgarh, through court. And on completion of investigation, charge sheet was submitted against the appellant under section 302 of the Indian Penal Code. After necessary formalities, the case was committed to the Court of Session, where the London Trial Court framed the charge. Since the appellant refuted the charge, pleaded not guilty, and claimed to be tried, the Sessions Trial procedure was resorted to establish the guilt of the appellant. In order to prove its case, the prosecution examined 13 witnesses, and also proved 8 exhibits Four material objects were also proved during trial. The defense plea is one of denial. The learned trial court, after assessing the oral as well as documentary evidence on record, came to hold that the prosecution has established beyond all reasonable doubt that the death of Bengojana, the wife of the appellant, was homicidal one, and it was caused by a heavy sharp cutting object. The learned trial court considered the evidence of the child witness PW 12 and found that the evidence is trustworthy and it receives corroboration from the medical evidence. Though the three witnesses, that is PW 4, 6, and 7, those three witnesses also did not support the prosecution case, but basing on the evidence of PW 12, which was found to be cogent, reliable, and trustworthy, and corroborating evidence from the evidence of PW 9, the medical officer, the learned trial court came to the conclusion that the prosecution has established that the appellant caused the death of his wife, Bengojana, alias deceased, Sasania, by means of pottery MO1, and accordingly found the appellant guilty under section 302 of the Indian Penal Code. The defense counsel's submission that the case should be on the conviction should be altered. No, the conviction should be for 304 of the Indian Penal Code was torn down by the learned trial court.
One judgment also.
Holding that it cannot be said that the deceased gave grave and sudden provocation to the appellant, and accordingly the act of the appellant would come within culpable homicide not amounting to murder. Srimati Meena Kumari Das, learned counsel for the appellant, submitted that since three witnesses, that is PW 4, PW 6, and PW 7, have not supported the prosecution case, the learned trial court should not have acted on the solitary evidence of the of a child witness like PW 12 to convict the appellant, in as much as the said witness was staying with in the house of our maternal uncle after the occurrence, and the chance of tutoring to the witness to depose against the appellant cannot be ruled out. The Land Council further argued that even if the evidence of PW12 is accepted, it appears that when the petitioner returned from the field, he was very much hungry and he asked the deceased to give him meal. And since the deceased did not provide him the meal and asked him wait for sign, in such a state, he got angry and gave number of blows, and that was due to grave and sudden provocation, and therefore the case would fall within section 304 part 1 of the Indian Penal. She further submitted that since the appellant is in judicial custody for more than 15 years,
16 years.
16 years, therefore his case of may be considered sympathetically.
On judgment also.
The Learned Council for the appellant placed reliance on the decision of this court in the case of Samlal Kishan versus State of Odisha, reported in 2019 Criminal Law Journal 780. Mr. Rajastri Patil and Additional Standing Counsel, on the other hand, supported the impugned judgment and argued that it is not the quantity but the quality of evidence that matters, and the London Trial Court testified. The London Trial Court, before examining, before recording the evidence of PW12, put some questions to PW12 and general questions on our education, family members, and relations, locality, etc. And the court was satisfied that the witness was intelligent enough to understand the questions and give rational answer. And he also understand the duty of speaking the truth. And he further argued that there was no axe to grind against the appellant, who is none else than the father, her father. And she stated that how the appellant dealt pottery blows on neck, face, head, and ear of the deceased. So this witness was subjected to lengthy cross-examination, and even suggestion has been given that she has been tutored by while staying in her maternal uncle's house to depose against the appellant, but she has answered it in negative, and in the cross-examination, the evidence has not been shaken at all. The Land Council further submitted that this is not a case where it can be said to come within grave and sudden provocation, as the when the appellant asked for the meal after coming from the land, the deceased asked to wait for some time, and it cannot be said that the conduct of the deceased was such that it caused grave and sudden provocation to the appellant, and that too bring a cautery and dealt successive blows on the vital parts of the body like neck, face, head, and ear. It is further argued that the doctor who conducted the post-mortem examination, Dr. Brackett exam PW9, has noticed as many as 9 external injuries and opined that the injuries were sufficient in ordinary course of nature to cause death. The doctor also examined the weapon of offense, which was seized from the spot, and gave his opinion that the injuries sustained by the deceased were possible by such weapon. Therefore, the London trial court was quite justified in arriving at the conclusion that it was not a case of grave and sudden provocation, and that through the evidence of PW12, which is getting corroboration from the medical evidence, the prosecution has successfully established the case against the petitioner, the case against the appellant. Adverting to the contention raised by the Land Council for the respective parties, let us first see whether the prosecution has successfully established that it is a case of homicidal death or not. PW9 conducted post-mortem examination. PW9 medical officer was attached to the medical officer THS Jaspur conducted post-mortem examination on 25 9/2008, and he noticed the following injuries, quote the injuries that have been there in page number 69, and he further opined that the mode of death was due to so and so, it was page 70. He also opined that the injuries were sufficient to cause death. In view of the available material on record, particularly the evidence of PW12, the inquest report, the post-mortem report, and the evidence of the doctor bracket PW9, which has not been second at all, we are of the view that the Land Trial Court is quite justified in holding that the deceased died a homicidal death. Now coming to the evidence of the solitary eyewitness to the occurrence, that is PW12, as rightly submitted by the Land Council for the state, the Land Trial Court put some questions to the witness, and preliminary examination was made, and the questions were put on the education, about the family members and relations, locality, etc. And the Land Trial Court, after putting such questions, recorded his finding that the witness is intelligent enough to understand the questions and to give rational answer. And he has also, the trial court was also satisfied that the witness understood the duty of speaking the truth. And since the witness did not understand the implication of no oath was administered to her. In our evidence, the PW12 has stated that on the date of occurrence at about 12 noon, while the deceased, who was her mother, was cooking on the veranda of the house, she was sitting near to her mother. And at that time, the appellant was a father came to the house from the land and asked her mother to give meal. The deceased told the appellant to wait for some time. Bracket like tikkiye ruho khai khaiba. Bracket ends with that. He further stated that On this, the appellant got angry and entered inside the house, brought a cautery, and dealt blows by dragging her mother, holding her tuft uh, on the cautery blows on the neck, face, head, and ear. The she raised holla, and the villagers and the paternal uncle, auntie, and others came to the spot, but her mother died at the spot, and the appellant was standing there, and her paternal uncle and some others tied her father by means of a rope. In the cross-examination, a question was put to the witness that whether in the uncle's house she was tutored to tell something against the tell something in connection with this case. She answered in negative. The PW 12 further stated that on the date of occurrence, she had not gone to the school, and when her father, bracketly the appellant, assaulted her mother, bracketly deceased by means of pottery, except C, no other persons were present, and the other persons came to the spot only after hearing her halla. She further stated in the cross-examination that she was at a distance of 5 cubits from her mother and was sitting outside the chali. She stated that she did not raise any halla when her father, when the appellant assaulted the deceased by means of pottery, and that her father dragged her mother 1 cubit to 2 cubits and then assaulted her. Nothing has been brought out in the cross-examination to disbelieve the evidence of PW 12, and there was also no earthly reason for PW 12 to depose falsehood against the appellant. The other witnesses like PW 4 has not supported the prosecution case.
For 6 and 7.
4,
Declare
6
hostile.
and 7. 6 and 7 have not supported the prosecution case. However, the law is well settled that it is the quality of evidence that matters, not the quantity of evidence, and the conviction can be based on the evidence of a solitary witness. His evidence appears to be true. The evidence of PW 12 having not been second in the cross examination, and more particularly when her evidence is getting corroboration from the medical evidence adduced by PW 9, we are of the view that the London trial court is quite justified in holding that the appellant is the author of the crime. Coming to the submission made by the learned counsel for the petitioner that it is a case of grave and sudden provocation, we find that the decision relied upon by the learned counsel, the in the case of Samlal Kishan, the factual scenario indicates that the accused and the deceased quarreled with each other, and then the accused sat over the chest and of the deceased and pressed her neck. This court has been pleased to hold that there is lack of evidence regarding motive, and the act was committed by the accused on the spur of moment in a petty quarrel between the husband and wife, and the appellant did not have the requisite mens rea to commit the offense of murder. And since he knew the actions of pressing the neck would cause such bodily injury which may lead to the death of the deceased, accordingly, instead of convicting the accused under section 302 of the Indian Penal Code, the conviction was altered to section 304, part 1 of the Indian Penal Code. The factual scenario in this case is completely different in as much as the manner in which the appellant assaulted the deceased by a sharp cutting weapon and on all the vital parts of the body, and the number of injuries caused would show his intention to commit the murder, and the background also does not indicate that there was any kind of grave and sudden provocation caused by the deceased to the appellant by asking him to wait for some time to provide food. Therefore, we find no infirmity. Therefore, this case, the submission of the learned counsel for the appellant that it would be a case of culpable homicide not amounting to murder is not acceptable. We are of the view that the learned trial court is quite justified in holding the appellant guilty under section 302 of the Indian Penal Code. The appellant stated to have remained in custody since for 16 years, as stated by the learned counsel for this counsel. There are, if he is entitled to get any benefit under section 432 and 433 of the CRPC, the appropriate government may consider the same in accordance with the principle laid down and the guidelines in that respect. We are not observing anything in that respect. It is up to the appropriate government to consider this and put a note of appreciation on the Mrs. Meena Kumari Das and also Mr. Tripathi.